Appeal dismissed. Apply.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 2.
2.
It may be listed after 3 weeks.
Why?
Letter. Your Lordship, I am appearing on behalf of Mr. O.P. Bhatti. His letter of absence is there up to 16/11. The matter may come
It's a
after
motion
3.
will issue notice. What's there?
Oh, there is one stay is also there.
We'll consider on next returnable date. All right. Same thing.
May it please, Your Lordship, I beg to mention supplementary item number 54. Lordship, with the consent of the other side, adjournment may be granted.
50?
Supplementary 50. 54, my lord.
54. Yes.
Apology, my lord. 57. 57.
57.
Apology.
Yes.
With the consent of the other party, my lord, adjournment may be granted for 2 weeks.
Why this is listed for orders?
My lord, notice has been issued. The compliance of notice has been done. The LCR has already been called. The matter is supposed to be listed for hearing. Simply listed for hearing.
We'll see. You be there.
My lord, today I am having one outstation. I am leaving outstation in the.
Just give the file. Item 57. Anyway, on the prayer of, you are for appellant.
Appellant.
On the prayer of Mr.
D. Rathi.
D.
Rathi.
Rathi.
Yes, sir.
Listed for admission. Her Mr. D. Rathi, learned counsel for the appellant. Next para. Office note dated 21/10/2024 reflects that the records from the Office of Railway Claims Tribunal, not office, records from Railway Claims Tribunal, Guwahati has been received list for admission after 4 weeks.
May I please, Lordship? I beg to mention, my lord, the item number 27, my lord.
27.
Yes, my lord.
Yes.
I'm from the respondent, my lord.
Yes.
With due consent of the petitioner, I beg to make an adjournment, my lord, for 3 weeks since my father-in-law expired on 18, my lord.
Yes, Mr.
D. Gogoi, my lord.
D. Gogoi.
Yes, my lord.
D. Gogoi, learned counsel, appearing for respondent number 2 and 4.
4, yes.
Press for and is granted for the 3 weeks time. No, press for listing the matter after 3 weeks.
Yes.
Press allowed, list after 3 weeks.
Obvious.
List the matter after 3 weeks.
May I please, Your Lordship? With the consent of other party, I beg to mention item number 22 and 24. In this
22
case, 22 and 24.
24.
In this case, my lord, we have to file additional affidavit to bring certain documents before this.
22
and 24.
24. This is what?
The recovery of excess amount paid during erroneously.
Okay. On the prayer, Mr. A.K. Dr. Learned CGC.
Yes.
And this is-
Standing Council of LGBRMs. Standing Council of the
Standing
Institute.
Council, Learned Standing Council, LGBRIMH. Huh? It's in there. List this matter after 4 weeks so as to enable him to file. What?
3 weeks, my lord.
3 weeks for what?
To file additional affidavit.
For filing additional affidavit.
Oblige, my lord.
May it please your lordship. My lord, I beg to mention item number 7, my lord. Today I am not feeling well. I am suffering from toothache, my lord.
What is the matter?
After 1 week.
What is the matter?
Disability pension, my lord. I am praying for disability pension. Only 1 week, my lord. Today I am not well. Suffering from S. Bora.
MSS Bora Learned Council to the President may submits that she is not keeping well today, for which he prays for listing the matter after 4 weeks. List after 4 weeks.
My lord, 2 weeks.
Make it 3 weeks.
Okay.
May I please your lordship?
Yes.
Item number 17, lordship. This matter, lordship may close because in the meantime petitioner got all the reliefs, lordship. I prayed for in the petition.
Parimal Das.
Parimal Das, yes.
You are
As Kanun Gul.
okay. So what relief you have got?
Lordship, he is praying for commutation of pension and a scheme, lordship, health scheme that has already been given to him.
Okay.
I am
MS
appearing for lordship. I am appearing
Respondent.
for respondents.
MS S. Kanungo, Learned Council for the petitioner submits that relief sought for in this writ petition has already been replaced by the respondents. Mr. Therefore, praise for closing of praise for President matter may be closed. Mr. MS
S. Borwa.
S. Baru, Learned CGC. CGC is present. Mr. Since the as the relief has already been granted to the petitioner, the writ petition is still closed.
Deeply obliged.
May it please your lordship, I beg to mention item number 4 and 41. Kindly adjourn for
One by
the
one, 4 is for what?
4 is for admission.
Yes. What is the matter?
uh,
What is the matter?
Writ petition.
Yes. I know it's a writ
My
petition.
lord, the matter regarding some surveillance worker and malaria worker, they were with similarly situated person. A writ petition was there which has passed an orders that they should, as long as the work is in there, they should be considered for their work. My lord, we approached this court. There was on the very first day, there was a direction to the government to find out whether we come according to that judgment or not. So if they have not brought it, I think that judgment.
We'll see. We'll see. What is the
All right, my lord. At 4, but 41, my lord, your lordship may adjourn the matter because there is a subsequent development. 41 may be adjourned. My lord.
41?
41 may be adjourned.
What subsequent development?
My lord, there was some disciplinary proceeding went on and something. It's a matter related to suspension. 41 may be
Suspension.
adjourned. Suspension.
On the prayer of Mr. P.K. Chaudhary, Learned Council for the petition, this matter after 4 weeks. 6 weeks.
Well, not 6 weeks, at least 2 weeks.
Then 4 weeks.
No, with the consent of the other side, in item number 18, my lord, I am for the respondent.
Yes.
This matter may be taken up after 2 weeks. My lord. The original, my lord, the original inquiry record. This is a case where the disciplinary proceeding has been challenged. But the original inquiry record has to be brought.
On the prayer of Mr. A. Ganguly,
Lordship.
Learned Council for the respondent number 1. List this matter after 3 weeks.
May I please, your lordship? Lordship, I beg to mention item number 6, lordship.
6.
In this case, lordship, they have filed their affidavit, reply, lordship. Filed their affidavit, lordship.
Your name is not there in the service book.
Lordship,
Your name is not in the service book.
lordship. So, lordship, I need to file.
Your second wife.
Lordship.
The family pension is being given to the first wife.
Lordship. Lordship, kindly.
What right you have?
Lordship, kindly allow some time to file our reply.
What reply? Nothing.
Reply, lordship.
When you had not been recognized,
Lordship.
maybe you have legally waited, but if it's not on record, how can you be allowed to, get the pension, family pension? But dismissing it.
No, Lordship, kindly allow some time, Lordship. I have to take some instruction.
It's 2017 matter.
Lordship may fix on Monday or Tuesday, Lordship. Short date, Lordship. Lordship may fix for short date, Lordship may be fixed, Lordship.
By filing reply, what more improvement you can bring in?
Lordship.
What improvement you can bring in by filing a reply?
And I have to take some instruction from our client, Lordship. That's why, Lordship.
Mr.
Ayu Chaudhary, Lordship.
Ayu Chaudhary, learned counsel for the petitioner, submits that press that he may be granted some time to obtain instruction. As admittedly, the petitioner is, the name of the petitioner is not recorded in the service book of the service book of the what is the name of that, your husband's name?
This is not
Service book of the Clever A. Sangma.
Lordship.
Clever A. Sangma. It is also noticed that the one, what is the name of the respondent?
This is not available with me.
One Srimati so and so, who is the wife of late Clever A. Sangma, is being paid the family pension. However, the petitioner submits that the petitioner is also a legally wedded wife, therefore she is also entitled. Considering the facts of the matter, further 3 weeks time is granted to obtain instruction. As evidently, the petitioner, the name of the petitioner is not recorded in the service book of late A. Clever A. Sangma. This
Okay, may I please, Lordship?
Yes.
Okay, with respect to item number 13, Lordship.
13. Yes.
Actually, both parties have some problem. His senior has gone out of the station. CGS is Sanjay Kumar Mehdi is out of, and myself. So it's a termination of disciplinary.
You are for
Petitioner, Lordship.
petitioner.
I am on behalf of respondent, Lordship. I am on.
He's on respondent.
On the joint prayer of learned counsel for the parties, list this matter after 6 weeks.
No, Lordship, after 4 weeks.
After 4 weeks.
May I please, your Lordship?
Yes.
I beg to mention item number 9 and 10 on the consent of the other side, and I am appearing on behalf of M. Bhagavati. My senior is has some medical emergency today.
What is the matter?
Matter is my petitioner is an outsourced Sahayak.
What right do you have?
I have no idea. Just for the day. Adjourn just for the day.
MS Jibora.
B. Talukdar.
B. Talukdar, learned counsel for the petition submits that item 9 and 10. His senior, Mr. M. Bhagavati, is having some health issues. Therefore, she submits that matter may be adjourned for another 8 weeks. Are you still working?
No problem.
Are you still working?
Lordship.
Are you working still?
Lordship.
Then in that case, 3 weeks.
I beg to mention item number 52, my lord. 52, my lord.
52.
In this case, my lord, service not completed to the respondent number 5 and 6, my lord.
Yes.
Kindly taken after 10 days, my lord.
Mr.
K. Kolita.
K.
Kolita.
Kalita. No, service not completed.
Yes, my lord.
Have you checked the record?
Yes, my lord. As per office note 22/10/2024.
Office note dated
22/10.
22/10/2024.
Yes.
Reflects that service report in respect of
Yes.
respondents
Person number 5 and 6.
5 and 6 are still awaited. List the matter after 4 weeks.
My lord, 2 weeks. My lord.
4 weeks.
May I please, Your Lordship?
Yes.
Your Lordship, there is one cover order, another CRP 37824.
Item
There are
3.
three analogous.
Item 3.
No, 1 and 2. 1.
1 and 3.
1 and 3. They are analogous. And another CRP IO already order has been passed by this court,
Saying what?
saying that Your Lordship, notice was issued until returnable date proceeding was stayed.
You want
No.
the judgment was fixed. It was better was fixed for judgment delivery.
Twice twice the
Now
judgment.
you want the stay. What's this?
No. Now the matter has gone to SR stage.
Okay.
At the time of judgment, the insurance company filed a petition under order.
Yes,
one
Mr. D. Mandal,
demon.
learned counsel for the petitioner. What's that impugn order? Page. By filing this revision petition,
10 and 11. 10 and 11.
petitioner has put to challenge the order dated 15/6/2024. Huh?
Yes, 15
Page,
2000.
page
10 to 11.
order dated 15/6/2024, passed by the learned tribunal, motor accidents, the learned member, motor accident claims tribunal, Golpara in MSA, case number 243 of 2017, whereby they are respondents here,
Yes. Insurance
whereby
company.
the respondents number 2 and 3.
No, respondent number 1. National Insurance Company.
No, by this order, what does it say? The insurer, owner, and driver of 3 of them.
No, three of the parties of other vehicle involved in the accident, they were impleaded. And the petition was filed by the...
It's okay then. 3 of them.
Yes.
Respondents, whereby the respondents number 1, 2, 3 have been allowed to be impleaded in the MSC.
No, Your Lordship.
Yes.
1, 2, 3, I have made them party, alleging they are the owner, driver, and insurer of the truck.
Yes.
Alleging that the accident occurred solely due to rash and negligent driving of the truck. Court impleaded owner, driver, and insurer of Winger, another vehicle also involved in the accident.
Now, who else? Who are the respondents here?
Respondent are 1, 2, and 3.
Who are they? Are they the owner and of
the truck
or
truck?
Then why you have not made them party? They have been impleaded now, as of now,
Yes.
wrongly
Your
or rightly. The owner, insurer, and the driver of the Winger are party here or not?
No, I have not made them party.
Why?
Because
Because they have already been impleaded wrongly or rightly.
Your Lordship,
They are the resident party.
Your Lordship, till date I filed the CRP IO, their names were not recorded in the claim petition.
Then how do you know that they have been impleaded?
The order says so, Your Lordship.
This is of 2007 June order. By this time, they might have been included. It's an order of June, in the
Yes.
month of June,
Now it
whereby
is,
the insurer, owner, and driver of vehicle within bracket Winger, bearing number S-16C-2290, have been allowed to be impleaded as opposite party number 4, 5, and 6 in the claim petition. List of issue notice returnable by 4 weeks, right? The learned counsel for the petitioners to take steps for service of notice upon responding 1, 2, 3, and 4. You have to implement them because you know they have been implemented. Anyway, it's up to you. Then let me see what sort of order. Proceedings, trial has been stayed.
Yes.
But then as per order 1 rule 10, at any stage, at any stage,
No, if it is,
either
it is only it is compulsion of law. Only if it is compulsion of law. Plaintiff cannot be forced to add party against his will.
Now, according to the court on the application,
No, the reason which has been assigned by the court.
See, rule 10 doesn't require even application.
If without application also court
Without
can.
application can be.
If it is under compulsion of law. Here it is not compulsion of law because I adduce evidence, they have also adduced evidence. If suppose due to non-joinder of party, my case may go.
Considering that it's a similar matter.
Similar.
Considering that
in the order itself,
this court has, the coordinate bench of this court has passed an interim order in a similar matter, being CRP within bracket IO bracket close 378 of 2024. Till the returnable date, the MSC case 243, the proceedings of the MSCT case number 243 of 2017 shall remain state. Next.
Your Lordship, in this case, I prepared a commercial suit as a plaintiff for recovery of some amount. After filing of written statement by the defendant, some discrepancies were found in our claim following addition of one defendant.
Well, just issuing notice, huh?
Your Lordship, I have prepared the case, so I am praying for stay. So let next returnable date.
Heard Mr. Dean Mondal, learned counsel for the petition. Next para. This is an application under Article 226 of the Constitution of India, challenging the validity of the order dated 0709/2024, passed by the Civil Judge Senior Division, within bracket Senior Division, number 3, Kamrup, within bracket M, capital M, bracket close, Guwahati, in commercial suit number 131 of 2022. Whereby the petition for amendment of plaint has been rejected. Issue notice returnable by 4 weeks. Then the petitioners to take steps for service of notice upon respondent, sole respondent, where is the within 2 days. The earlier one also will say 2 days. Not 2 days, 3 days, make it 3 days. No, 2 days.
No, Your Lordship. Next 2 days holiday.
What is it's opening? It's
Monday.
Within 7 days.
Within 7 days.
Within 5 days. Yes, where is just the order?
Order is at page 11, Your Lordship. The finding of the court is that it will change the nature and character. Lordship, addition of
correct.
No, Your Lordship, I want to insert the name
You
of one
cannot allow
defendant.
As you are well aware, if it amounts to, if the amendment is allowed, which changes the nature and character of the plane.
No, Your Lordship, it will not change the nature and character. I will add one defendant, and there are some words which are to be amended. Entire claim will remain the
Still
same.
returnable debt. No, next one. Having considered the submissions of plan of counsel for the petitioner and on perusal of the report, a perusal of the impugn order, it is provided that till the returnable debt, the further proceedings of commercial suit number 131 of 2022 shall remain stated.
Highly obliged. Three orders is similar order.
Similar
passed in
is that of item
One.
But what is the MSC number? MSC number will be.
MSc number is 242/17.
242. Earlier one is 243.
243.
Pending one is 241.
241. Highly obliged.
Please, Your Lordship. My Lord, Your Lordship may peruse the order dated 14/12/2016.
Yes. There is already a judgment in 2440 of 2007.
ये नंबर तो पूरा दुनिया में है कितनी हमें भी नोटिस करके दिए
My Lord, otherwise, if your Lordship perused page 43, there is a direction already, my Lord.
There was a direction, then thereafter, my Lord, I was allowed to, there was a contempt file, then I was given a liberty to file another writ petition. Page 46. My only prayer, my Lord, the judgment at page 43, if can be renewed, my Lord, that much.
No.
My Lord, as per
whether you agree that this judgment covered his case.
My Lord,
were you a petitioner?
My Lord.
Were you a petitioner?
My Lord.
Then why second writ petition?
Because, my Lord, here it was when we filed a contempt, they have not implemented on the representation. The contempt was dismissed on the ground that we could not place our representation in the contempt application. So then the contempt application gave us a liberty to file a second writ petition. Around 2007-3
Why second writ petition?
2007-3 SCC 689. There was a direction in the SLP where the salary to be paid. When salary was not paid, then the particular contempt was filed. Then contempt got dismissed. Then there was a subsequent writ petition filed. Court held that subsequent writ petition is maintainable on the account that it gives a fresh cause of action on the implementation of the order by the respondent. That is, if I am not wrong, 2007-3 SCC 689. Other way around, this same page judgment at page 43, if your Lordship can.
What do you say? It's
my Lord, page 43, because there was a direction in the year 2014, my Lord.
Yes.
And that direction, my Lord, if your Lordship is pleased to dispose of on the basis of that direction, then because there is a direction to examine the case of the petitioner in light of the another judgment, my Lord.
Well, same prayer.
Why is we stopping you? Why don't you examine it? This page 42 is order is by same petitioner.
Same petitioner.
Why unnecessary we should pass an innocuous orders? When you know that there is a direction to consider their case, why don't you consider?
Yes, my Lord.
one after another, why we should, and at that too.
But only an observation, they will consider my case.
It would be indifference.
Or only one consideration, that they will just consider the judgment passed in such and such case in page 43. That much will dispose of the writ petition.
In fact, this court is not to pass any order over and again. It cannot be allowed like this. You know that this is a direction.
Yes, my lord.
Why you are not, I mean, don't take advantage just because they cannot file a contempt.
Yes, my lord. I understand,
the
my lord.
day of contempt has been sought. Doesn't mean that you will not do anything.
So that kind of observation
Because
is...
these are, I think, in my view, these are all unnecessary.
Yes, my lord. I understand. But if your lordship...
we'll close it with the direction,
Okay, sir.
considering the order passed so and so.
Yes,
well,
my lord.
it is expected that the
Yes, my lord.
petitioner, the respondent will consider.
Yes, my lord.
That will do.
So more record something. You should be mindful of your business as an authority. Should I pass that? No.
My lord, if it helps the petitioners, my lord.
Add Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. And also heard Mr.
D.P. Bora,
D.P. Bora,
Standing Council, Health and Family Welfare Department.
learned counsel, standing counsel. Health and Family Welfare Department, Government Master. For all the respondents.
Yes, my lord.
How many petitioners?
29.
29. 30, Lachu Suikya and 29 others.
Yes, 29.
29, all right, 29.
Huh?
29. There is a list of 29 petitioners.
29.
29 only. Huh?
Same as page, annexure 3, page 28. Same. 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 It is same.
Same.
You were the party in the page 43.
Page, it is 28.
Huh?
43. Page 43.
No, the page 43, you are not a part. You are also part.
No, no.
Okay, this is your case one. This is your writ petition.
No. Page 43, same.
The petitioners were appointed, engaged, huh?
No.
Engaged as superior field worker and field worker, right?
No. Supervisory worker. Superior field worker and field worker. Superior field worker and field worker.
Yes, superior field worker and field worker. Field worker. During the in the year 1994, during the epidemic of malaria with high mortality in the state, mortality, Mr. The petitioners in the petitioners had filed a writ petition which was registered as WPC 6112 of 2014, seeking consideration for regular employment, as they have been working, as they have been engaged, continuously engaged, maybe on seasonal basis. This court by an order that is 17/12/2024, having been considered that the judgment of an order dated 22/08/2014 in writ petition in WPC number 597 on instruction of the learned counsel for the on instruction placed by the learned counsel for the respondents that they would examine as to whether the case of the petitioner is covered by the said judgment or not. Directed the respondents to examine as to whether the case of the petitioner is covered by the said judgment and order, and if it is found that in fact it is covered, consequences thereof will follow. Next paragraph. Mr. P.K. Roy Chaudhary, learned counsel for the petitioners, submits that despite such direction and the undertaking by the learned counsel for the respondents to examine the case of the petitioners, examine the grievances of the petitioners, no action was initiated. Therefore, they had approached this court by filing a contempt petition, which was dismissed with a liberty to file a writ petition. Accordingly, the present writ petition has been filed for a similar direction. Next paragraph. Mr.
DP Gora,
learned standing counsel, fairly submits that the authorities would examine the case of the petitioner as directed by this court in the earlier round of proceedings, writ proceedings in WPC 6112 of 2014. Next. Having considered the submissions, having considered the submissions of learned counsel to the parties, and considering that this court has already directed this court, on the submission of the learned counsel for the respondents, that the respondents would examine the case of the petitioner in the earlier round of litigations. I deem it appropriate to dispose of the present writ petition with a direction to the respondent authority to examine the grievances of the petitioners as has been directed by this court in a wide order dated 17/12/2014 in WPC 6112 of 2014 within a period of 2 months from today.
Obligation.
It exists still disposed.
Obligation.
May I please, Lord?
Yes.
Lordship, in this case, we have challenged the discharge order, Lordship. Lordship, make is 31, Lordship. The petitioner was initially appointed as a contractual employee, Lordship, as a data entry operator, Lordship. And thereafter, his services was subsequently extended, Lordship, considering his performance, Lordship. But in this case, without giving any opportunity, Lordship, the petitioner was discharged. by order dated 31/3/2017.
Now,
And this
your
honorable case
service has been discontinued. You are engaged on temporary basis.
Yes, okay.
Nothing remains.
But Lordship, the appointment is a condition of the that satisfactory service, Lordship.
Where it
The
is? Appointment order.
Lordship, page 17.
Engagement of
You are
data
hereby
entry.
engaged on contract basis in the water cell department data entry board under the district water cell of the water with effect on data of your joining that and for a period of 11 months. Further, you are liable to be discharged in the event of unsatisfactory performance. But Lordship, a mere perusal of the impugned order, Lordship, there is no whisper regarding the unsatisfactory performance, Lordship. Lordship may peruse the page 26 and 21, wherein it is stated that petitioner service is satisfactory. Page 21.
11 months.
Subsequently, it was extended, Lordship.
See,
By
it's
issuing,
okay.
by
With
issuing,
effect of your joining and for a period of 11
Yes,
months, then you have to read. Further,
But-
you are
but-
liable
but
to
that-
be
that-
discharged in the event of
that
this is
was-
within 11 months.
that was subsequently
You are
extended.
kind enough, you are gracious enough to allow you to continue.
Lordship, page 21. Lordship, may kindly peruse the page 21. 21 and 20.
This condition,
Yes, sir.
it's within 11 months,
Yes.
not beyond.
Subsequently, by issuing the similar appointment order, there's a petitioner service was extended, Lordship.
Where it is?
Lordship, page 21.
21.
Page 21. It is in the year 2015. This is to certify
This
that.
is certificate.
And thereafter, page 26, Lordship.
Hmm?
The person's own letter, Lordship. Page 26. In the year 2016. That means the petitioner service extended, Lordship. The petitioner is fourth column, Lordship, Raqibul Islam. There is no so-called, Lordship, regarding the unsatisfactory service.
Any law.
I know that my
It's a
limited,
contract for 11
my
and
limited.
they were gracious enough to.
But Lordship, the national justice, because we are approaching the 220 under a court of equity, Lordship. But there must some, and this honorable court is passed an interim order, Lordship, whereby this impugned order was stayed in the year 2017 itself, and thereafter the interim order was continued. They have not come.
We'll close everything today. No interim, no complication of interim or continuance.
They have filed their affidavit, Lordship.
Saying what?
They have filed their affidavit stating that the department has internally wrote to them that the petitioner's service is not satisfactory. But there is no whisper regarding that no so-called notice was issued to the petitioner in pursuance to that letter. Lordship, may their affidavit filed on.
See, your nature of
Yes,
engagement is
I am aware that my limited.
How you are appointed?
Lordship, what the petitioner's appointment is a pursuant to interview process.
Interview?
Yes.
Very
Interviews.
Any advertisement?
Yes, Lord. Case 15, Lordship. Case 15 and 16. Interview board, Lordship. Similar case 16.
Where's the advertisement? Where's the advertisement?
Lordship, we have not annexed that advertisement, Lordship.
There was no advertisement. So how can you manufacture that?
Pursuant to a selection process, he was engaged, Lordship.
But there's no advertisement.
Lordship,
I'm not inclined.
It's.
Your Lordship,
You are admitting that you have not issued so-called notice.
No, Your Lordship, actually the standing council is unwell, Your Lordship.
I'm not concerned.
So I wanted to take the adjournment, but we didn't take the consent. So
Yes?
like the standing council is unwell, Your Lordship. So
Who is the standing counsel?
RSDR, Your Lordship.
Who are you? You are appearing for a theory.
yes.
You don't have any authority to, power to argue.
Yes, sir.
You don't have the power.
No, because my name is not there in the Wakalat Nama, Your Lordship.
the difficulty. We want to dismiss the writ petition.
And Lordship, rightly or wrongly, in our paragraph 14, Lordship, we have stated that reasonable opportunity was not granted,
It is
and
not
this
required.
this
It's
is
not
a
required. Natural
the
justice.
order
is-
of impunity is the punitive in nature.
Sir,
Lordship.
it's not in all and sundry cases. So as the contractual employees appointed for 11 months or a certain period is entitled to have to be continued if his service is discontinued
Lordship, I come up with
without
Lordship, I come up with authority.
what
Lordship,
come up,
Lordship,
there is nothing.
Lordship may fix the matter next week. Any date, Lordship. Any date next week.
Next week.
Yes.
Next week. Next week for dismissal.
Yes, Lordship.
Dismissal.
Yes.
Yes.
Lordship may not record that.
Mr. Heard Mr.
K. Kolita.
K. Kolita, learned counsel for the petitioner. The petitioner was appointed the petitioner was engaged on contract basis as data entry operator with effect from the date of his joining for a period of 11 months in the watershed cell cum data center of Bongaigaon district under the district watershed development unit of the integrated watershed management program within the Act. The service of the petitioner has been extended from time to time. When the last being 26.
Yes, Lord.
From time to time. On 16/07/26, a letter was sent to the performance report of some of the data entry accountants and data entry operators, including the petitioner, were forwarded to the chief executive officer by the project manager, WCDC, within bracket IWMP, bracket close, Barpeta, Bongaigaon and Dubri district, wherein the performance of the petition is shown to be satisfactory so far then. So far then. It also had a remarks that the reelection of duty as and when noticed, may lead to discontinuation. By virtue of this performance report, it is contended that the petitioner is still continuing. Thereafter, the impugn order dated 31 by impugn order dated 31/03/2017 addressed to the petitioner by the project manager WCDC within bracket IWMP is Bongaigaon district, whereby the service of the petitioner has been discontinued and released with effect from 31/03/2017. This court time of moving this writ petition.
Yes.
Where is this order?
17.5 Lordship.
17.5 of
2017 Lordship.
Seventeen 2017 has state the order of interim order of continuation, that is 3103/2017. On the ground of the statutory performance report, that is 16, no, on having been considered that a performance report which shows satisfactory performance, that is 16/07/2016, and for non-disclosure of reasons in the discontinuation order. Accordingly, the petitioner is stated to be continuing as data operator, data entry operator till date. Still you are serving. Still you are serving.
I don't have that instruction also.
Then last. After arguing the matter for at some length, Mr. K. Kalita, the counsel for the petitioner, press for some time to bring to have research on some judgment which may support his case, support his submissions in the present case. Next one. Considering the submissions and by providing further opportunity to place any law in his support, let this matter be listed after a week.
Yes, sir.
After a week.
Hello. Interim order may continue also. Interim order may. Hello.
May I please, Your Lordship,
Yes,
10 days
madam.
time may be given to file reply.
Yes.
10 days time may be given to file reply.
What is the matter?
So in this case, petitioner pays for promotion to the post of LDA.
Yes.
Petitioner pays for promotion to the post of LDA.
Okay. For promotion, are you eligible?
And
Are you eligible?
let's say I'm senior to the Retrospective.
Seriously.
Senior, Lordship.
What is the rule says? Mode of promotion, method of promotion. What rule says? Is seniority come merit or merit come seniority?
Seniority, Lordship.
Or it's a hybrid? Madam, tell us what rule says.
Let us see senior, Lordship, then there is one number 4.
No, what rule says?
My lord, the rules say it's in rule number 7, my lord.
Yes.
Assam Ministerial District Establishment Rules 1967.
Yes.
It has been amended in 2015, my lord. If I may read, my lord.
Yes, read it.
7.3 reads the education qualification. He must have passed the degree examination in any discipline from a recognized university or any other examination declared equivalent thereto by the government. The petitioner doesn't have a degree. my lord.
Yeah.
What's the matter? In the task for time being my senior lecturer, Lordship.
Who is your senior?
Mr. Fixation.
It's a great opportunity for you to argue. Have you not read the brief yesterday night?
Yes, Lordship.
Simply senior will not do. Madam, you have to go with the it has to be by the rules only. When you are not qualified, how can you be promoted?
That is true, that's it. That is true, that's it.
Who is for respondent? Yes. What do you say?
Rule says, I'm
Rule says what?
rule says, my lord, qualification must be BA pass. I'm BA pass, my lord. That is why they
Only BA pass.
Yes, my lord.
Suppose if a person is MA,
No,
master
no.
degree,
Amen. I'm BA,
he will be overqualified.
my lord. Earlier rule, it was only HSLC.
When they post vacant, when the promotion was made,
Promotion order, my lord, I have filed affidavit, my lord, additional affidavit, space.
forget about it. We will go to come to the. You just tell us. What is the impugn order? When you were promoted,
Promoted, my lord, impugn order at page 28, my lord. Annex 13.
yes,
This is approval, my lord.
2018.
It is approval, my lord.
Pranab Jyoti Kalita, Dekha. No order.
This is the approval. Thereafter, promotion order was
So
issued.
amendment was in 2015.
15, my lord.
That of nothing.
He filed this petition in 2018.
The time being, Lordship. Time being.
I mean,
Yes.
Otherwise, the matter will be fixed on Monday, my lord.
why?
Lord, some difficulty, my lord. If it may be fixed on Monday,
You
you
want to go somewhere else?
No, my lord. There's some other. It may be taken up, my lord. They also have actually filed a affidavit in opposition, which is not on record. If it's taken up on Monday, that will also be on record, my lord. That can be
In that
disposed
case,
of, my lord.
MS Sren, no, Mr. MS Sren Learned Counsel for the petitioner. Press for and is granted further 3 weeks time to file affidavit in reply to the affidavit is opposition filed by the respondent. You have not filed.
We have filed already, my lord.
You have filed a reply to
No, Lordship.
all
Yes.
filed by the respondent. Huh? This now let's see. Yes.
Can you see the order dated
And Bora.
23/9/2024, my lord.
And Bora. Who is appearing? Who is PNRD? Yes. Last time on 23, she has sought for a time to file response. What is the matter?
Madam, my lord, petitioner was appointed as a peon, my lord.
Yes.
Thereafter, he was transferred, frequently transferred, 3 times he was transferred, my lord.
Yes.
At the time of transfer, this pay slip and my lord, service book had not forwarded to the new place of posting, my lord. Thereafter, his salary was stopped. Thereafter, he filed a writ petition before the Honorable Court, my lord, that is page, my lord, 27, my lord.
Yes. What is your prayer?
Here, my lord.
To
Regularize the service of the petitioner for the period of 2005 to 2016, and with all constitutional benefit, including the salary, so that they may not be break the service of the petitioner.
Are you still serving?
My lord.
Where is that order which you are referring? Where is that order which you are referring?
page 27, my lord.
27.
Start page 27. Is a detailed order, my lord. First, we'll see page 31 in view of the above, my lord. From in view of the above.
Yes.
In view of the above, respondent, more particularly the respondent number 2 and 3, the Commissioner of Panchayat and Rural Development, Assam, and
It's okay up to 2005. Thereafter, what had happened?
thereafter, I am receiving my salary, my lord. In back period, my salary has not been regularized.
Which period? This judgment is up to 2005. Thereafter, what happened again? For the period from 2015 to, what does it mean? May 2005.
They will submit the affidavit, my lord. The details what happened, my lord, thereafter.
See, look at this period from 19/4/2015 to May 2005. Read it again.
Yes.
Read it. Please read it.
In view of the above, respondent, more particularly respondent number 2 and 3, Commissioner of Panchayat and Rural Development, Assam, and Project Director, DRDA, Karimganj, are directed to release the salary of the petitioner for a period from so and so within a period of
Not
8
so
weeks.
and so. Read it this.
19/4/2015 to 2005.
Yes.
My lord.
What does it mean?
Within a period of 8 weeks from the date of receipt of the certificate orders, particularly.
Apply your mind, sir. What is this? It's a clerical mistake or something like that. Read it again. 19/4/2015 to May 2005.
Actually, my lord, it should be 2005, from 2005 to 2015.
That's why I'm asking.
My lord.
How do we understand this?
It should be 2005 to 2015.
We have to file a review for correction of this.
That's for time being, my lord.
Have you understood this?
My lord, conducting advocate, my lord, he is code number 1, my lord.
Why have you? Because there's a reason I'm saying. This court has directed on the next day, if no return affidavit is filed, it will proceed.
My lord. Yeah, sometime, my lord. After some time. After some time, just I have this brief, my lord. That is what.
Where is Mr. Enbora? MS Enbora. What is this? You have taken time and there's an order of this court.
Lordship,
If by next date of listing the respondent does not file their return, the requisition proceeded will be proceeded in accordance with law.
Lordship, affidavit is sent for vetting because officers are.
What is your instruction?
It's under process, Lordship now.
No, what is the instruction? Under process, I know. You must have drafted the affidavit.
Lordship. So, sorry,
Not
Lordship.
Mr.
A.K. Azad. A.K. Azad.
A.K. Azad, Lalit Counsel for the petitioner. And also, the MS next para, MS Enbora, Lalit Standing Counsel PNRD, submits that the affidavits as directed to be filed. The affidavit in opposition has been sent for vetting.
So Lordship, to extend my legal.
Therefore, she pressed for further 2 weeks time
To extend
to
my
file
legal.
affidavit in deposition. It is noticed that this court on 23/09/2024, while allowing the non-standing counsel to file the affidavit in opposition by today, and if no affidavit is filed, the petition shall be proceeded. However, Mr. A.K. Azar, learned counsel for the petition, has also sought for time to prepare the matter. Considering the above, let this matter be listed after 6 weeks.
3 weeks, madam.
4 weeks.
Lordship.
Can I pay for a date, madam?
You want to dispose it of, you are not able to place the facts.
May I
Yes.
pray your Lordship? Lordship, I'm praying for 2 weeks time to file affidavit
What affidavit?
on behalf of the health department.
What is the matter? What is the matter? Madam, what is the matter?
Lordship, it is about
Don't appears for the petitioners on call on the prayer of MS
IDAS
IDAS
on behalf of the
on
Upamana.
behalf of the London Standing on Health and Family Welfare Department. List this matter after 4 weeks so as to enable the state respondents to file their response.
Please, Your Lordship.
Yes, sir.
The matter pertains to selection and appointment, my lord.
Yes.
While order dated 11/9/2024, my lord, the Social Justice Department was included and they were to furnish some instructions today.
Yes. Yes,
Social Justice and Department.
Yes.
Now, the petitioner, my lord, there are two petitions, my lord, out of the same selection list. They applied for a post, my lord, in the grade 3, my lord.
By the university?
No, my lord, this is state police recruitment board, my lord. State police recruitment, state level police recruitment board, my lord. They advertise some post, my lord, for persons with disabilities. The petitioner before your lordship is a person with disability.
This talks about Guwahati University. This is appointment of recruitment of what?
Grade 3, my lord.
Grade 3?
Grade 3.
In the
various departments, my lord.
All the departments?
All the departments for persons with disabilities. They applied, my lord, they were selected, and thereafter, my lord.
All departments means what?
My lord.
It's a particular, not particular
No,
department.
not a particular department. That is special recruitment drive, my lord.
For all departments?
Yes. for basically for the persons with disabilities. They applied, my lord.
He said something else. Sir, this is said, he said all this recruitment is done by Guwahati University.
What university?
Guwahati University also published the finance department was also. The medical test has been conducted.
May place the facts, my lord.
May be obtained from Guwahati University Medical Education Research Department. What does it mean?
Probably they are saying that they are not in the
Also,
process
we are
of recruitment.
only for the logistic support, Lordship.
Probably
Nothing
they are
else, Lordship.
not in the process, not involved in the process of recruitment.
No. They are saying they are saying that all the relevant information, documents regarding the recruitment, pursuant the advertisement. Are you challenging the advertisement?
Yes. Not advertisement. But selection order, my lord.
30/12/2018 may be obtained from Guwahati University Medical Education Research Department.
There was an advertisement, my lord, for recruitment in various departments for persons with disabilities.
Yes.
They applied, my lord. They were selected. Then thereafter, my lord, the selection order came up. There,
What is the selection order?
Yes, my lord, if my lord comes to page 30, it starts from 35 onwards. 35 onwards, if my lord comes to page 37.
This is by Government of Assam Social Welfare Department.
Yes.
Then
my lord, kindly come to page 37. Further, it may be mentioned here. Am I with your lordship? Page 37.
Following two candidates selected in special.
Following two candidates selected in this special recruitment drive for persons with disabilities whose disability is less than 40%, as authenticated by the Joint Director Health Services Kamrup, has been rejected, and therefore you are requested kindly not to issue appointment letters to these petitioners.
Yes.
Now, my lord, they have come. The health department has filed their affidavit.
You are these two persons.
I am these two persons. Two petitions, my lord.
Yes.
The health department have come up with their affidavit, my lord. They, in their affidavit, states that there was some complaint with regard to authenticity of the physically disabled certificates. Complaint with regard to authenticity. Now, my lord, the Persons with Disabilities Act, my lord, they provide a procedure for dealing with the complaints. Not what they have done here. If my lord, for a moment comes to 47, page 47. Running page 47. No?
Yes.
That is
the certificate of selected for appointment to gratuity person various department in connection with special recruitment of person with state level police recruitment board.
Am I with your lordship, my lord? This is order, my lord, letter, my lord, 19 November 2019. That is a letter dated 19 November 2019.
Yes,
yes. With reference to the subject cited above, I would like to inform you that as desired by the government for constitution of special medical board to verify the complaint about the authenticity of the certificates of the selected candidates for appointment to grade 3 posts in various departments in connection with the special recruitment drive for persons with disabilities categories selected by the state level recruitment board Assam and conducted by the social welfare department, you are hereby requested to kindly constitute special medical board and fix a suitable date. Normally, what they have done with regard to the complaints, they have constituted a special board. There were some complaints with regard to the authenticity of the certificates. What they have done, they have constituted a special medical board. But what is the procedure enacted in the Act, my lord? For a moment, if I may take a logic to the Act.
It's okay. We'll go by what they wants to convey by this instruction. What is that selection? Let me see this. That's 35.
That is the order, my lord.
Yes.
35.
The government has recorded document to issue a Was there any advertisement?
Yes. Advertisement, my lord.
Which advertisement?
At page 14. Page 14, my lord.
30th December 2018. Yes.
That is the advertisement. And if I come to page 15, down below Water Resource Department, grade 3 post, junior assistant district level, one post was vacant. Here in this post, the petitioner was selected. Thereafter, because of some complaints, they constituted a special medical board.
Yes.
And the special medical board has said that
You are below 40%.
Below 40%. No, my lord, the Act provides a procedure of dealing with the complaints. My lord. The section 62, Commissioner to look into complaints with respect to matters relating to deprivation of rights of personal disabilities. Now, the rule says,
it's okay. Just wait. This instruction, you cannot hands your put up. You cannot put your hands off social welfare. The appointment order issued by you.
No, Lordship. Appointment was
Approval is by you.
it's for Social Justice Department.
Social Justice Department.
Not social welfare.
Okay.
The
social welfare has
government looks after it.
Social welfare department has been bifurcated into particular departments.
So that's what I'm saying. It is
In the persons with
Social Justice and Empowerment Department.
Yes,
They are now
Lordship, we don't have any. We have not done. We have not done anything, Lordship. We
But
have
it's selects approval by you only.
approval, Lordship. After medical test, the medical board has given us the list. As per that list, we have approved it, Lordship.
That's why I said you cannot put your hands off.
They have to follow the procedure for dealing with the complaints.
Lordship,
Have you filed the affidavit?
No, Lordship.
You filed it. How these things? It's not that you just cannot passing the buck that you obtain from this university and medical college and all those things. You cannot do that. What you have acted on it, that you have to place on record. How you have acted. Why you have approved this. Because in
There was
approval it says these two persons, the petitioners, is found to be below 40%, so no appointment order shall be issued. On what basis you are saying? Maybe on the special medical board.
Yes,
whatever. You bring on record that. Isn't it?
The health department has brought on record
Yes.
that a special medical board was constituted to deal with the complaints. But the special medical board is not the authority to deal with the complaints. It is the commissioner of the persons with disabilities, and he has to put the
Who is
person.
the commissioner?
My lord.
Who is the commissioner of the social justice? Social justice.
No, not the social justice. Persons with disabilities.
Yes.
He has
that things will be done by the mooted from the social justice department only. Isn't it?
Yes, Lordship.
Then you have not done that. You simply relied on the medical board reports.
Yes, Lordship.
As per the act, you have to go by
Lordship,
that.
we don't have any doctors, so to verify their disability, we
You
have
don't verify as per the act what the act says. Provision as per the act of the provisions of the act you have to do. That's all.
to
By
verify.
placing this, no, we'll direct them to file affidavit. You cannot observe your duty.
No, Lordship, we don't have any doctors, so we have to rely on some experts, Lordship.
You will not follow the law.
No, Lordship, we have to follow the law, Lordship.
Law is provided in the act.
Rule 42.
And there was a notification also, Lordship.
If you have not followed, also you file an affidavit. It is not going to help us.
They should not help.
The reason of the impleading the social justice department has a reason. It is their nodal department. You have to mutate the issue where it has to go as per the act. You have to do that, initiate that. Now you are just putting your hands up, saying that no, you obtained from the Guwahati University. What is Guwahati University has got to do it?
They have conducted the examination, Lordship.
Only the Guwahati University.
Yes, Lordship.
And it has been done, my lord, because of political intervention.
Forget about
If
it.
I may bring,
Let us clarify this. Why this has been implemented and what could be the
yes,
reason.
yes. Whether this
File an
regarding
affidavit,
42
we'll allow them to file an affidavit. And we'll see. We'll take a call. Not Mr.
PK Munir.
PK. So inshallah, counsel for the petition. Both will be listed together.
Both. They're tagged together.
As directed by this court on 11/09/2024. Mr. R.M. Das.
C. Sharma, Lordship.
C. Sharma, London Standing Council for Social Justice and Empowerment Department, Assam, which was implemented on the same day. Placed an instruction dated
26 September 2024.
26/09/2024. Mr. On perusal of the instructions from the issued from
the Director of Social Justice and Empowerment.
Director of Social Justice and Empowerment Department.
Assam, Lordship.
It doesn't disclose anything as to how the provisions of the Act of Death
Persons with disabilities within bracket equal opportunities protection of rights and full participation in 1995
has been invoked. Strangely, it appears to have passed the buck to the Guwahati University and Medical Education Research Department, which has got nothing to do with the such implementation of the mandate of the law in the present case. Having considered above, Mr.
C. Sharma,
London Standing Council Social Justice, London Standing Council is granted 2 weeks time to file.
Lordship, can it be 3 weeks, Lordship?
3 weeks time to file affidavit clearly indicating the implementation of the mandate of the law and clearly indicating as to how and whether the mandated law are being implemented in the state. In regard to the disabilities Act are being implemented or not in the state.
more particularly rule 42 so may I pay for date if possible
After 3 weeks, just give. Yes.
I'm appearing for the health department.
You record all their names.
Much obliged.
In chronological order, as per the array of parties. Got it, madam? Yes.
Obliged.
16.
The petitioner before Lordship is Muslim
It
married
became
registered.
infructuous.
Not
It has
infructuous,
become
madam.
infructuous.
No.
That has been.
There is another challenge, my lord. So it can be by
You revive it. when
my
it is-
pleadings are complete. So it may be hard.
No. As on today, that has been repealed. The basis on which you are claiming,
My lord.
it's been repealed.
No, my lord, because my license was cancelled
See,
only
you
because
are
I was
like-
arrested, my lord.
You are arrested.
Yes.
In terms
This
of
court can't take bail, my lord.
in terms of the, are you challenging your arrest? No. You are
I-
challenging the
That case
cancellation.
is pending, my lord. That criminal case is pending, my lord. Evidence is, my lord. So without completion of that case, my lord.
We'll ask you to
I blame
approach
Mr.
again.
Mal. Without completion of that case, how can I be said that I have done this offense, my lord?
without completion of the criminal case, my lord, because they did not make any inquiry, my lord. Only because of my arrest, they just cancelled my license, my 95,
Then
94.
see,
That they don't have that
the
power.
basis on which you have been granted
My lord.
license
My lord.
on cancelled,
Yes.
it is no longer there.
No, my lord, because only because of my arrest, without investigation, they should have made an inquiry, my lord. They did not give me the notice.
Sir, that is
Even
something-
cancellation, my lord.
Sir, that is something different. License was issued on under which law?
But that is there, my lord.
If that is there, nothing remains.
Then in this case, Elox will do one.
We'll say in view of the repeal of the so and so act, this petition has become infructuous. However,
yes,
you will be given liberty to in future
My
if
lord.
it is revived.
Reiterate the matter, my lord. Yes.
In any case, it cannot be. Maybe the challenge may be the repeal. Repeal, I think.
My lord, that after that, my lord, the Assam compulsory registration of marriage,
Yeah, just
Muslim
give
marriage
that
and
thing.
divorce act. My lord, it was, my lord,
Heard, Mr. We're closing it. We'll give
we
you a
liberty.
liberty.
We have no
Reiterate the matter, my lord.
Yes.
That can be given.
Heard, Mr.
Yes, Mukhtar.
S. Mukhtar, learned counsel for the petitioner, and also heard Mr.
Jay Hindi.
Learned.
Or SC revenue, lord.
Huh?
SC revenue.
Learned standing counsel.
Revenue and disaster management.
And respond number. Standing counsel. Government State Council for respond number 4 and 5. Next para. Considering that what is that law? Muslim marriage.
Muslim marriage.
Assam Muslim Marriage and Divorces Registration Act 1935.
Just wait, where it is? Considering that the Assam within bracket Muslim Marriages and Divorces Registration Act, 1935 has been repealed and replaced by a new law.
That has not been.
No, it is had been already been in one of that forever sent for the procedural the governor.
Has been repealed.
Has been
Already been
repealed.
one it is not been.
Has been repealed. Has been repealed by the governors. That thing has been repealed. Repealed.
That is under challenge. That
Under which the license of what?
License of the Muslim Marriage Register and Kaji.
License
For working as Muslim Marriage Register and Kaji.
What?
Muslim Marriage Register and Kaji.
License for Muslim marriage and
Muslim Marriage Register and Kaji.
Register
and Kaji.
Muslim marriage register and Kaji was issued and cancelled by the authorities, which is the subject matter in this writ petition. The writ petition has become infructuous as of now. It has become infructuous, Mr.
However,
infructuous. Accordingly, the writ petition is dismissed as infructuous. Next, however, the petitioner may approach. Petitioner is granted liberty to approach again in the event the
stipulation is
Assam Muslim marriage. I will not say in the event any occasion arises as may be permissible under the law in future.
My
May praise the Lord.
Yes.
Here they have not filed their affidavit till date.
The issue here is, Lordship, we had applied for an advertisement was issued for Lordship Class 1 Grade 3 of the Assam Financial Service. At the time when the advertisement was issued, the requirement was that a degree in arts, commerce, or science. That was the requirement, Lordship. We participated in the written examination. Written examinations were held. Subsequently, that condition was modified in the year 2020 after the written examinations were held, and that was given a retrospective effect. That is what we were agreed, and accordingly we had come up before this honorable court. But they have not filed the affidavit, the health department.
But in any case, you are found to be.
Yes, Lordship. We had not.
You have appeared.
We had appeared.
Selection is out.
Lordship.
It's completed.
It's completed.
Selection process is completed.
Nothing
Lordship, remains.
But Lordship, there was an observation that the selection would be subject to the outcome of the case because this.
No, you may not have been found to be ineligible because of that rule. Retrospective, not on that.
Lordship, no, Lordship. At that point of time.
Suppose the rule has been applied retrospective. Lordship. On the application of the rule with retrospective effect, has you been disqualified?
Lordship, because
has you been found ineligible?
Lordship, our cases, Lordship, since the rule was subsequently modified, in the retrospective application was
I
given,
understand.
Lordship, that criteria changed. Therefore, if the persons who had now been selected, many of them fall under the retrospective.
Forget about that. Whether now, subsequent development, after this selection, whether your disqualification or whether your non-selection is on the base of that rule.
Yes, Lordship, because.
Is it?
Because, Lordship. Lordship, because the persons who have been selected on the basis of the subsequent
Forget
rule.
about others. You first establish your rights, sir.
Lordship, when we had applied, the requirement was degree in arts.
You have not been made ineligible.
No, Lordship, in the select list, my name was not published.
So that's what I'm saying.
Lordship.
When you applied,
Lordship.
You have not been made ineligible because your application has not been rejected that you don't, fulfill that rule, retrospective, rules which they have
Lordship,
applied.
if I may kindly submit. The subsequent modification was that degree in any course would be entitled.
Agree, it may not be permissible.
Lordship.
But then you have applied.
I have applied.
You have been allowed, you have set for the exam.
Lordship.
Selection is out.
Lordship.
You are not found to be selected.
Lordship. No, Lordship.
Now, what relief can you get?
Lordship, during the selection criteria, after the written examinations were published, they changed the very foundation of the eligibility criteria.
It's all right. Are you saying so? Show us on the implementation of the application of these rules with retrospective effect.
Lordship.
Had you been made ineligible or had you been not selected on the basis of this rule?
Lordship, on the basis of these rules, the persons who have been selected.
Forget about others first. I am asking about you. We'll go to them
Lordship,
later.
they could not have been selected. That is our case.
We'll go to them. But you have participated.
Lordship.
Have you been made ineligible or have you not been selected because of that rule?
No.
By applying that rule?
No.
Then?
But Lordship, the
What
person,
right you have?
Lordship, because when the rules would not have been changed subsequently and thereby given.
Are you saying that these persons who have been made eligible as per that rule, with the giving application of that rule, with retrospective effect, your chances of selection has been diminished?
Because Lordship, the earlier criteria
How
was
can that be-
Lordship, because the earlier criteria was degree in arts, science, and commerce. Three branches.
You could have understood if your application or your non-selection is based on that rule.
Lordship, what I am submitting is, Lordship, the earlier one was degree in 3 branches specific. Now, Lordship, subsequently they have made it.
Let us
ineligible.
agree. Let us agree. They could not have applied that rule with retrospective effect.
Then, Lordship, the
What
person.
made you ineligible?
Lordship, then, Lordship, those persons who have
What
been,
advantage you will get?
Lordship, then those persons who have been selected, those who did not have arts, science, and commerce, they could not have come in, Lordship. They could not have come in.
Yes, who is for the state?
Lordship, Mr. B. Gogoi had applied.
My Lord, I have just informed the council, my Lord, finance council. my Lord.
I think there is a law. Law is very clear. You cannot rely on the your case on the basis of weakness of the other.
No, Lordship, what we are submitting is they could not have changed the rule subsequently and given it a retrospective.
Understood. They could
That
not
is-
have then what I mean, what infringes your right?
Lordship,
You have applied.
We have applied.
You have been qualified. You sat for the exam. You have not been selected.
We have not been selected, Lordship. Persons who had
Anyway.
Lordship, they are yet to
You
file
file an
their
affidavit.
Their
Who is
affidavit.
appearing?
Mr. B. Gogoi had appeared on the
He has a point. You have amended the rule. How you can, unless there is a express provision of retrospective effect, you cannot just apply like this. He has a point. But so far as his relief, he cannot be. It would be rather akin to academic exercise.
Academic exercise.
We agree your point. They could not have. But what infringes you? Nothing. Just somebody got some advantage. You cannot, I mean, have your right from that. They have the right from that, their advantage or disadvantage.
Those persons have been selected on the basis of this modification
So
which
what?
would not have been done. Which
Have
would
you
have
been not selected because of this?
Yes, Lordship. We are ousted.
Have you been not selected because of this application of this rule?
Lordship, because of application of this rule, the other persons came in the fora. We
Okay,
were ousted.
What about you?
We were ousted, Lordship.
What about you?
We were ousted for this purpose, Lordship. Because that
So
is-
so is that.
Lordship, that from the record, let them file their affidavit.
See, you are also eligible, whether that rule or not rule. And some of them got advantage by application of that rule. And selection was done.
And they were selected.
They were selected. Doesn't matter. You show us that you have your non-selection is because of application of that rule.
Lordship, will give me then one opportunity. I will collect instructions.
My lord.
You inform.
My lord, I will inform my lord. My lord will record the name of B. Gogoi. I will tell him that my lord is directed to file the affidavit.
Heard, Mr.
A. Chakraborty.
A. Chakraborty, learned counsel for the petitioners. Mr. B. Gogoi.
B. Gogoi, ma'am.
Learned standing counsel.
Finance Department.
Finance Department. Rest for is granted 3 weeks time to file affidavit. You establish your right first.
Obliged.
18.
May I please, Your Lordship?
Yes.
In this matter, may I prefer some time for filing affidavit in reply in opposition?
Why reply is required?
A reply in
What is the
respect of
matter?
affidavit in opposition filed by respondent number 5.
Yes. What is the matter, sir?
In fact, what happened in this case, Your Lordship?
Yes.
Mr. S. Islam is the counsel in this matter. He
You
instructed.
tell us the case, otherwise you are dismissing it.
I am not aware about the matter.
You must
because
be
he
aware.
instructed me just to appear.
Engagement as a driver.
That sometime may be granted, Lordship.
Why you are appearing before the court without looking into the brief?
Owing to some personal exigency, he is not in court.
Do you want that all your petitions should be done, I mean, work should be done by the court? Some least assistance we require.
Lordship.
This is your case. Never appear without brief.
Lordship.
Mind you. Mr. So-and-so, learned counsel for the petition. Petitioner, learned counsel appearing on behalf of Mr.
S. Islam. Lordship.
S. Islam, learned counsel for the petition. Space is granted. Further 6 weeks time to file. 4 weeks time to file. Affidavit in written. Not further, huh? 4 weeks time to file.
I am appearing for the health department. Obliged.
Record her name.
May I please, Your Lordship? My lord, here in this case, matter pertains to the family pension, my lord.
Yes.
And the petition filed by the second wife, my lord. And first wife also appeared and submitted her affidavit in opposition, my lord, in this case. Para 8 and 9 is relevant, my lord, in this case.
affidavit submitted by the first wife, that is respondent number, my lord.
You are
I am the second wife, my lord.
Yes.
Respondent number 4, my lord. She filed the affidavit, my lord, at para 8, my lord.
Saying
Your
what?
lordship. She stated that they have mutually agreed, and both of them, and praying before this honorable court for release of the family pension.
You close it.
Since it was held up,
Whatever you do it, you have
my lord.
you have settled the matter outside.
Yes, sir,
the
lordship.
Underground will
Let
close
them
it.
let them release our family pension.
Heard Mr.
I alum.
Alam,
My lord.
Learned Counsel for Deputy, and Mr.
R.R. Gogoi, lordship.
R.R. Gogoi
For a forest department, lordship. Respondent number 1, 4, and 5.
Standing Counsel,
Forest department.
Forest Department. For respondent number
1, 4, and 5.
1, 4, and 5. One more, 2 lots. And Mr. Swenso for it. You?
Respondent number 3, lordship, R.K. Talukdar.
Who is this? Who is for respondent number 4?
Respondent number 4 is first wife, my lord.
Who is appearing?
He yesterday night he told me that but due to his personal reason, he could not appear, my lord.
Who?
So your lordship, my matter may be come up next week, my lord. Before his presence, my lord, your lordship may dispose of.
No, we'll believe you. We'll take your words as gospel truth.
My lord.
We'll take your submission as gospel truth.
That is on record, my lord. They have stated in the affidavit in opposition. So his presence is required because he has submitted the affidavit.
Mr.
Ayalam,
Learned Counsel for the Mr. Ayalam, Learned Counsel for the petitioner, submits that the petitioner and the respondents number 4.
Respondent number 6.
Respondent
number 6, who is the first wife, have settled the matter amicably. Right?
And same is brought before this honorable court. The mutual agreement is before this honorable court.
Where it is?
Your lordship may kindly peruse the affidavit in opposition. My lord.
Mutual agreement. Have settled the matter. Have settled the matter mutually by entering into a deed of mutual agreement on 04 2022. Please.
At para 3, your lordship may have found it in the mutual agreement.
You had approached the court earlier also.
My lord.
There was a direction.
There is the your lordship may kindly. Order is at in my petition, my lord. Para 28, page 28, my lord, and the 11 part is para 30, my lord.
Page
30, 11 part starts from 28, my lord.
20
30 30. That is last para, my lord. There is a direction from this honorable court.
Live consent agreement of parties hearing and Then what is your prayer in this writ petition?
Phase 10, my lord,
Monthly pension
directly responded to release the monthly pension to the petitioner.
Not only to you, equally. What you have decided?
We have decided equally both of us.
To both the wives,
Both the
both the petitioner and respondent. You will direct that. All right.
My lord.
Therefore, he prays that the matter may be closed with a direction to release the family pension equally to both the petitioner and the
Respondent number 6.
respondent number 6.
Lordship, the pension amount gets deposited in the name of the person who was nominated in the service book, and respondent number 6 has the name in the service book. So the authorities will release the pension in the account of the respondent number 6. Thereafter, respondent number 6 will disburse the same to the petitioner. Lordship. So
That will create a problem, my lord.
Because that's the agreement they have.
That will create problem. That's why I am before your lordship, and earlier petition filed by her husband.
Whatever you do it.
Department
as per the rules, equally, because they have agreed.
They have agreed, and there is nothing to show.
Family pension, their wives, it's recognized, accepted.
Let them, very well, Wills.
Next, the essential, constable respondents have not have also accepted that the petitioner and the respondent number 6 have mutually settled the matter. Next paragraph. By filing this, the petitioner has filed this writ petition for a direction to the respondent authority to release the family pension to her. It is noticed that the petition is the second work of late. What is that? Late
Rostom Ali, my lord.
Late Rostom Ali, and the respondent number 6 is the first wife. The family pension is being disbursed. It is being paid to the respondent number 6, who is the first wife. The parties, the petitioner and the respondent number 6
No, you cannot disperse.
have entered into a mutual deed of agreement whereby
On 4th of November 2024.
on 04/11/2022, whereby they have agreed that the particulars, all the necessary particulars for pension, including the names of both the both the wives, namely the petitioner and the respondent 6, be included. However, due to certain inadvertent mistake, the name of the petitioner was not recorded in the nomination paper. Next paragraph. In earlier, who has filed this writ petition?
Earlier writ petition filed by her husband, my lord. That is Rostom Ali.
Okay. The next paragraph. Late husband of the petitioner and the respondent number 6. Where is page?
Page 28, my lord, in my writ petition. Annexure 5. Annexure 8, my lord. Page 2A.
MD Rustam Ali had approached this court, but approached this court
To include the name of the second wife also, my lord, in the
for
nomination.
direction to include the name of his second wife within bracket petitioner hearing in the pension book public nomination papers along with his first wife. The petitioner, the late husband of the petitioner and the respondent 6 had been working since 1960 as a superintendent in the office of the Conservator Forest, Northern Assam Circle, Tezpur, and he has retired from service on 31/03/1995. The writ petition being WPC 2637 of 2013 was disposed of by this court by an order dated by an order dated 23/04/2015, whereby the principal chief conservator of forest, government of Assam, we considered the representation filed on 27/11/2012 by the late husband of the petitioner and the respondent 6 by Mr. It has also directed the petitioner to produce his two wives, produce the late husband of the petitioner, the petitioner and the respondent 6, to produce them before the concerned authority so as to ascertain the veracity of the claim of the two wives professing the Mohammedan faith. After the inquiry, if it is satisfied, the name of the petitioner shall be included. No. The name of the petitioner hearing within bracket second wife shall be included in the nomination paper and submit the same to the office of the Accountant General from Assam. It is submitted by the learned counsel for the petitioner that as of today, the name of the petitioner, although he being legally wedded second wife, as permissible under the Mohammedan faith, has not been included despite the direction of this court. Next, having considered the submissions of the learned counsel of the parties and also considering on having been perused the agreement, mutual deed of agreement dated 9/11,
2022, my lord.
Huh?
9/11/2022. Sorry, 4/11/2022.
Huh?
4/11,
2022. And the order passed by order of this court passed on
Petition number 2637 2013.
passed in WPC 2637 of 2013. That is 2304/2015. I deem it appropriate to dispose of the matter with a direction to the respondent authorities to include the name of the petitioner along with the respondent number 4.
Respondent number 6.
In the respondent number, you are
Lordship, I'm for the Forest Department.
Respondent number?
Respondent number.
Conservator with the boss who has to do it.
1, 4, and 5.
No, respondent number 1, 4, and 5. No, respondent number 1.
Let it be respondent number 5, Your Lordship.
Then respondent number 1, 4, and 5. Namely, you just write their name by designation. To include the so-and-so, name of the so-and-so, and send it to the Accountant General.
Accountant General. Respondent number 3, my lord.
Accountant General. Thereafter, the respondents are directed to pay the family pension to the respondent, to the petitioner and the respondents in equal proportion.
Here I may say one thing, Your Lordship. There the issue is that even this order has been passed, the first wife, the respondent number 6, she will get the pension benefits.
Okay, then in that case, we will equally to pay the family pension in equal proportion in accordance with rules. Whatever. It is distance disposal.
My lord, time limit, maybe time limit.
Within 2 months from today.
In accordance with law, Lordship.
Obliged.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, I'm seeking for an adjournment, Your Lordship. The learned standing counsel for the Soil Conservation Department. Your Lordship, she is unwell, Your Lordship. I'm praying next week, Your Lordship, any date. Your
On the last occasion also the same prayer was made. Matter regarding that I am being paid, these petitioners have been paid salary at pre-devised case. So we are praying that at least 6 pay, if not 7 pay, should be given to us.
Admit and hear it.
And
because
secondly,
it will need require
no. Secondly, my lord.
Detailed deliberation.
No. Secondly, my lord, our VRS application has been approved by them. Our VRS applications have been approved by them, and they have sent it the proposal along with the bills regarding area pay and.
You are objecting to the admission of the writ petition.
No.
Are you objecting?
No.
We'll admit and it
No.
is
Kindly,
for hearing.
if it is sent for hearing, that will take some time. If
Who
they
says? Who says?
No.
Will be
Because it is-
listed for hearing. Listed for hearing.
The matter is not that big enough. My lord. If they get
No,
the instruction.
all this claim requires a detailed deliberation. You just cannot allow what you pray. On mere asking, on mere praying on your behalf, you just cannot allow.
Yes.
We'll have to hear it.
Yes.
Is not it?
Or Lordship may kindly proceed after
This
Let
is
she
this
take-
is which department?
This is Soil
Application.
Conservation Department.
Plantation Crops Development Corporation. It's
Yes.
a corporation.
Corporation, and they are under
within the
under Soil Conservation Department.
Is it?
Yes, Your Lordship.
So let
Within the meaning of state.
Yes.
Other authorities.
Yes.
Government corporation.
Yes. Government of Assam. Let the matter come up immediately after the Diwali vacation, my lord.
Why?
Let she also come, and she might have the instruction on the basis of instruction the matter may be disposed of.
On the joint prayer of learned counsel, no, heard Mr. So-and-so learned counsel for the petitioner. Petitioners.
Yes.
How many?
16.
Petitioners. Mr.
D.S. Dekka, Your Lordship.
Learned counsel for the petitioner submits that MS.
R.S. Dury, Your Lordship.
Mr.
Mrs. R.S. Dury.
MS R.S. Dairy. Learned standing counsel is unwell,
Yes, Your Lordship.
for which he prays for adjournment the matter for another 2 weeks. Mr.
Can a date be fixed?
Prayer not being objected to by learned counsel for the petitioner. Prayer is accepted and let the matter be listed after 2 weeks.
Can a date be fixed?
We have so many matters after that, after 14. After 14.
Thank you.
19.
Thank you.
Much
obliged.
This is 25. 25. Yes.
My lord, I am for the petitioner, my lord.
Yes.
So I want small accommodation, my lord.
Why?
Due to my personal difficulty, my lord, I could not prepare the case last night, my lord. So may I pray, my lord?
What percent difficulty you had encountered last night?
Last night, my lord, I got a severe headache, my lord.
Is it?
Yes, my lord, I could
Is
not.
it so secret that you just
No,
said
my
that
lord.
personal difficulty?
With the consent of the other side, my lord,
Everyone-
any day fixed.
all your friends and all of us would like to know what personal difficulty really you had
Personal
encountered.
difficulty in the sense, my lord, I got a headache, my lord, severe headache, for which I could not prepare.
Keeps
Only that much, my lord, otherwise nothing
keeps
else.
recurring. Body, headache, backache, it's keep recurring.
Lordship, kindly fix it the matter any day next.
What is
day.
the matter?
Matter, my lord,
Otherwise,
is that,
it's of 2023, is not it?
my lord.
What is the matter anyway?
Matter is that, my lord, I filed a application under land grabbing, my lord, and the trial court at the instance, my lord, granted the status quo order, my lord. When it was been violated, I filed the application violated, then it was not considered. Accordingly, I have approached the Honorable High Court, my lord. Honorable High Court, my lord, at the initial stage, clarified the stand of Section 8, subsection 2, man,
Yes.
and granted status quo order. Interim order from this honorable court, my lord. Lordship, kindly have a look date, my lord.
On the prayer of Mr.
J.I. Barbo.
J.I. Burboya, learned counsel for the petitioner, and prayer not being objected to by learned counsel Mr.
A.K. Gupta, man.
A.K. Goswami.
A.K. Gupta, man.
Gupta.
Yes.
Let this matter be listed after
First week, my lord, any day first week.
after 3 weeks.
Only.
26.
May I please your lordship?
Yes.
My senior is in Lexington for another court. May I kindly fix the matter at 2, lordship? Can it be at 2?
What is the matter?
My lord, I have been imposed a major penalty under the service law by the bank. My lord, I have been demoted from the post which I was holding.
So we'll admit this. It will require
Your lordship,
hearing.
because I am in the verge of retirement. I am verge of retirement.
We'll admit this for hearing. We will give you a fixed date.
My lord, but it can be because within 2.5 months I will be retiring. My lord.
It's okay.
So my lord, it will affect my
You-
pensionary benefit and everything.
You are in a job.
My lord, I am in the job, but I will be retiring my pensionary benefit.
Consequential. This will follow.
Still then, my lord, in the month of November.
It depends. If your writ petition is allowed, consequential will follow.
My lord, correct, my lord, but still
Since
then.
since you are working now, your retirement will not have any
But not those creates a lot of other problems. In the month of November, your lordship.
Mr. P.K. Rochor, learned counsel for the petitioner, and also
S. Yasmin.
S. Yasmin, learned counsel for the respondent.
Respondents.
All the respondents.
Yes.
But as a chance on 7th, my lord, if your lordship.
Not 7. After 14. Because we have fixed so many matters.
On my lord, 19th.
It's of no use fixing when you cannot dispose it of.
No, 19th is a hearing day, my lord. 19th. November 19th.
Admit this petition. No, admit the next list for hearing on
19th November.
19th. Pleadings completed.
Pleadings completed.
Yes.
Much okay.
How the party necessary honorable compulsion?
So in this matter, respondent number 5.
Yes.
It's not a necessary party because the entire issue pertains to a payment of ex-gratia, wherein Indian Oil Corporation, represented by the chairman at the Delhi office, that is the actual necessary party, and they are there. But we have been unnecessarily made a party. We are the Assam Oil division of the Indian Oil Corporation. This is a subsidiary. My instruction is to pray for your lordships to strike off this name.
Have you filed any application?
Lordship?
Have you filed any application?
No, lordship. Just making a verbal submission.
You are for all.
I'm appearing for respondent number 5. I have power to appear only for respondent number 5.
Okay.
And for Indian Oil Corporation, notices were issued, but I don't think anyone has appeared till now. Neither I have received any instructions to appear for them. I just wanted to make a verbal submission on that aspect, you know. The petitioner will also have an objection to striking off the name of respondent number 5 because I don't think there is any player from.
Who is necessary party?
The other parties are necessary, but
you are not necessary party.
Not necessary party. Assam Oil division is a division
No,
under Indian Corporation.
Whatever you want to do, say you file affidavit.
I'm praying for striking off respondent number 5. Only that. I leave it to your lordship. I'm just making a submission because that's my instruction.
Or else you file an application. We'll see.
Yes, lordship.
I am appearing for 8 and 9 lordship.
Then
BRPL lordship, this year lordship.
Who is the party to
My lord,
redress?
IOCL, my lord.
Who is IOC?
Respondent number 2.
Not
From respondent number 2, lordship.
2, 3,
7.
yes.
4,
6, 7.
Notice has been served.
Yes, yes, my lord.
No one is appearing.
No one is appearing.
So what is to be done? What is your role?
Lordship, because the petitioner has been retired from the BRPL before the 2005. Actually, the scheme 2003, the ex-gratia scheme was introduced by IOCL.
So why you are not filing affidavit?
I have filed today, Lordship, today.
They have filed it today. I have received it also today.
Okay. So will it be suffice?
No, my lord.
For deliberation of the matter?
No, because IOCL has to be filed.
In that case, heard Mr. So-and-so, learned counsel for the case. And also heard Mr.
A. Sharma.
A. Sharma.
R. Kapoti. For respondent number 8 and 9.
I'm for respondent number 5.
No appeals for the other respondents. MS R. Kakoti has submitted that she has filed the affidavit in opposition today.
Lordship may kindly also record my submission just for the record. Because that instruction was there, so I submitted it. It's on record.
If necessary, I will file the affidavit in reply regarding that affidavit.
The learned counsel of the petitioner may file his reply, if so advised. There is a reply to the affidavit in opposition filed by the respondent number
8 and 9.
8 and 9. Other respondents may also file their response. Let this matter be listed after 4 weeks. You file an appeal application.
After 2 weeks, my lord.
4 weeks. We'll see. You said that without their.
My lord, I'll try to contact them, my lord.
Yes.
Then, my
The
lord, maybe
benefit that they are seeking is from Indian Oil Corporation.
I do not have any objection
Oil
of striking of their
Corporation-
name, my
India Oil
lord, if they are not
Corporation,
necessary
who
party.
you are representing.
No.
8 and 9. BRPL, I am
May I just submit what has happened? BRPL.
It's okay. After 4 weeks.
Yes, Lord, sir.
We'll hear you after 4 weeks.
Much obliged.
May it please your lordship. Lordship,
Yes.
this is an appeal under section 30 of the Workmen's Employees Compensation Act, lordship.
Yes.
The substantial question of law, lordship, I have mentioned at page 7 of my memo of appeal.
Page 7.
Yes. Lordship, I have mentioned 3 substantial question of law. Lordship, in this case, the driver, he renewed his driving license. So, Lordship, he is no more a disabled person. And the compensation was calculated as if he was a disabled person.
Yes.
So
What about this is for the first time.
first time.
So we'll issue notice next day.
Admit. Lordship will admit because it is a statutory appeal.
No, it's okay. We'll issue notice that this on next date we'll frame this substantial question and admit.
But Lordship,
without framing the substantial, we cannot admit.
no, this is because this
So
is under
that's why we'll just issue a notice for 3 weeks. All right.
they might not
Who is the appellant?
Insurance company.
That's why.
Yes.
That's the reason. Take steps. We'll issue notice for 4 weeks. All right. And MS Ardi Majumdar, the counsel for the appellant. Challenge. No. This appeal has been filed under section. Is filed under section 30 of the Employees Compensation Act 1922 against the judgment and award dated 04/07/2024 passed by the Commissioner, Workman Compensation, in WC case number 02 of 2022. Issue notice returnable by 4 weeks. The appellant to take a stage for service of notice upon responsibility by this course and all.
And LCI may be called out.
Call for the LCS. This after 4 weeks.
Then Lordships, I have a stay petition. I think that also will be taken up in the hearing.
Which one?
Lordship.
IA.
IA is there.
Yes.
But then since it is not admitted.
On the day
yes.
We'll try to frame the substantial question
Yes,
and then admit and then we'll consider.
Fine.
Once it is admitted.
Highlight law.
My lord, MSC appeal number 544 of 2024.
First time. Listed for the first time.
Appellant Pranati Das.
Yes.
Wife of the deceased person.
This is for the first
this
time.
This is an appeal for enhancement.
Okay. Heard Mr.
D. Kuli.
Direct counsel for the petitioner. Next paragraph. This present appeal is directed against the appeal is filed under section 173 bracket 1 clause of the Motor Vehicle Act 1988 against the judgment and award dated 12/7/2024 passed by MSCT. Remember MSCT Number 2, Kamrup, Guwahati. In MSc case number 1202 of 2016. For enhancement of the award, compensation, enhancement of the compensation. Yes, sir. Very good. Issue notice. Yes. Issue notice returnable by 4 weeks. Appellant to take steps for service of notice. Respondent number. All the responses.
Yes, ma'am.
We have to take steps and all.
Sorry, my lord.
For issuing notice returnable by 4 weeks.
Okay.
And we'll have to take a step. Then take a step for service of notice after response. Huh? Yes.
51.
No appeals for the petitioner on the call. This is an appeal. Same order, huh? Against the judgment and award dated 20/06/2024 passed by the member motor accidents, member MSC, Noga in MSC case number 140 of 2020. Issue notice returned by 4 weeks. Petitioners to take, appellant to take steps for service of notice after response. You send all this to see, then you get returnable same one. 4 weeks.
Obliged.
Then in that case, her D. Mondal, the great learned council.
Obliged, Your Lordship.
May it please your Lordship.
Yes.
Lordship, on the request of Mr. K.K. Bhatta, I am appearing in this matter.
Why?
He asked me to adjourn the matter for the day,
Why?
as he is not
Will
well
issue
today.
notice. Same order. Will issue notice. Take first steps. Not be MS so and so learned counsel for the appellant. This is an application appeal under section same 173 motor vehicles act against the judgment and award dated 29/04/2024 passed by member MSC. Number 2, Kamrup within bracket M bracket close in the MSC case number 172 of 2017. Issue notice returnable by 4 weeks. The appellant to take steps for service of notice appellants. All respondents. How many respondents? No. Respondent number, all respondents, 1, 2, 3, and 4. Huh? Barrister.
Lordship, I am appearing for respondent number 1
You
to
are
3.
appearing?
Yes, your Lordship.
Respondent number?
1 to 3, your Lordship. 1 to 3, 4, your Lordship.
Then in that case, MS.
AG.
Yes. Steps change it. Before that, huh? Since MS,
AG Chaudhary, your Lordship.
AG Chaudhary, learned counsel enters appearance on behalf of entered appearance and accepted notice on behalf of respondent number 1, 2, and 3.
3 and 4, your Lordship.
1, 2, 3, and 4.
Yes, your Lordship.
Mr. Defoe, no comment. You want to file, you have the receipt, you have the received a copy?
Yes, your Lordship, I have received the copies.
The appellant to take stage for service of notice of respond number 5, huh? 5 is proposed. 5 and 6. 5 and 6. Right? After 4 weeks.
May I please? This one appeal for enhancement.
Yes?
Appeal for enhancement.
Enhancement.
If we should go at this system.
Appeal under so, huh? Section 172 same against the judgment and award dated 22/07/2024 passed by MSCT Bongaigaon in MSC case number 241 of 2019, praying for enhancement of the compensation. Issue notice returnable by 4 weeks. The petitioners to take steps for appellant to take steps for service of notice.
Lower court record plus. Case record payment.
Call for the case. Call for the record from the MSC. Going on, something going on.
Well, we have filed our affidavit in opposition today in the morning, and I have served
Yes,
the copy.
What is the matter?
My lord, he has challenged a selection process which was abandoned by ONGC. Now, an advertisement was issued. Subsequently, it was cancelled. Now, he is seeking a direction for
Where is this cancellation?
At page 38, Your Lordship, Annexure 5.
Cancellation notice required. Yes.
Cancellation.
What right you have?
Lordship, in this case, for
Even if you are selected, you don't have a right to be appointed.
In fact, they were not selected. It was a provisional.
Even if I am saying,
Yes.
even if you are selected, you don't have a right to be selected, appointed.
Absolutely, Lordship.
So,
in this case, Your Lordship, the petitioner, as per the advertisement applied, and he had applied the CVT.
okay.
Lordship.
That's why you are before us.
Yes, Lordship.
Have you issued a press advertisement?
No.
Because of the pandemic. Why you have cancelled it? What's the reason?
My lord, because of COVID, there was a fall in market price of oil and all. We have explained it in our affidavit, but perhaps it is not in the record, my lord.
Sir, up to them.
Lordship.
Forget about.
Lordship.
Look for a better opportunities.
Absolutely, but Lordship, we may allow for file reply in respect of this affidavit, Your Lordship,
But
because
this
we have
what
annexed
right
some,
you have? How can
annexed
you
some
challenge?
judgment. We have annexed some judgment passed by the.
I have seen that judgment.
And that judgment has been stayed by the apex court, my lord. We have stated in our affidavit. A similar issue was arose in Tripura, and Tripura High Court also.
Then in that case, we'll list after the judgment of the disposal of the SLP that.
And my lord, that decision of the Gujarat High Court was on a different, because there was some union pressure. Facts and circumstances are not similar, my lord. You want, my lord?
Heard Mr. Swenson, Land Counsel for it. Where's the affidavit?
We have filed it today, my lord. It is not on record. That is why, my lord, lordship. The problem is we had filed the affidavit earlier because we could not serve a copy, and that affidavit got misplaced in the filing section.
Heard Mr. Swenson, Land Counsel, Mr.
S. Chakravarti.
S. Chakravarti, Land Counsel for the
Respondent ONGC.
Respondent ONGC submits that he has filed the affidavit. Filed the affidavit in opposition today. This is not placed before. Placed in the record. Placed it to verify and place the affidavit in opposition. in the report.
So-
Mr. So-and-so, the consultative petition. First for and is granted for the 3 weeks time to file affidavit in the class.
My lord, may I pray for a date? Can it be on 22nd? My lord, in this case, ONGC has engaged Senior Counsel Mr. I. Chaudhary. He has asked me to get a date from your lordship. 22nd.
So, why senior counsel is required?
My lord, ONGC
will not hear him. We'll hear you.
My lord, ONGC has engaged Mr. I. Chaudhary, and I am under an obligation to apprise my
Tell
lord.
the senior counsel that court is not required to hear him. We'll hear Mr. Sandeep Chakraborty.
No, my lord, it's not Sandeep, Suman Chakraborty.
Suman Chakraborty.
Well,
Yes, sir.
We'll pray. I'll pray for some time in this case, Your Lordship.
For
The
what?
Finance and the Health Department has filed their affidavit, Your Lordship,
Yes.
negating my claim. So I have to counter to that, Your Lordship.
We'll dismiss it if it is negative.
Or I have to come with the reply, Your Lordship. In this case,
Heard Mr. Suman counsel for the petitioner, who submits that he may be granted 2 weeks time to 3 weeks time to file affidavit in reply to the
affidavit filed with the Finance Department and the Health Department.
Filed by respondents.
Yes, Your Lordship.
Praise the Lord. Let's this matter after 3 weeks.
Deeply obliged, Your Lordship.
May please, Your Lordship. We have
Yes.
filed our affidavit today only, Lordship. It's
Yes.
not in the record.
They have given an affidavit admitting my claim to the family pension. My father's, after the death, I am the daughter of the second wife.
Okay.
But they, as per the new pension rules, I am entitled to get. They have admitted.
They are admitting.
Admitting, Lordship. But
That was
then,
there.
Respondent number 4 also filed on affidavit in opposition, Lordship, which was not in record, Lordship.
If you are admitting, why?
Well, the private respondent is the one who is the first wife. They have
List next week. We'll
on
dispose it
Wednesday.
of- If you are admitting it, we'll just.
Lordship, we have certain issues which has to be raised. Lordship, a date may be fixed next week on Wednesday for hearing.
Why?
There are certain issues.
You
which
are
has
for
to-
whom?
Respondent number 8, Lordship. The
Who is
first one.
respondent number
He is
8?
the first wife who has not put my name in the kin certificate, which ultimately on query raised by me, it was cancelled by the government. Now their prayer is that the family pension has to go to the first wife, who will distribute among the others.
So you are agreeable to that?
No, my lord, because she is the stepmother who has not put my name in the kin certificate. How I am, after a direction, how I am entitled to get from her? How could I expect that money to be received from her? My prayer is this: the mother is the first wife, a son is there, and I am the daughter of the second wife. So it may be distributed among the three.
Proportionately.
Proportionately, that much.
What rule says? It's rules permits that. So.
Well, the family pension, family pension rules. What it says, I have put your lordship in. Find it, my lord.
You are representing?
I'm for respondent number for Animal Husband and Veterinary Department.
If they are admitting, rule must be permitting.
Page 44 in my refutation.
Mr. P.K. Roy Chaudhary. Next week we'll see. Or
Wednesday.
after
Wednesday.
Lordship, I have some problem in
After 2 weeks.
Wednesday.
After
So,
2
Lordship,
weeks.
first week of November, I am available here, Lordship. First week of November, Lordship.
You are busy.
No, Lordship, I'm there in first week of November.
That's why I'm after 2 weeks.
Because, my lord, I am studying without my father's.
Okay.
I was
That's the reason we're fixing after 2 weeks. We'll dispose it off. If they are admitting, what remains?
Let it be on 7th, my lord.
Yes.
Lordship, a humble prayer, a copy may be served to us also, the respondents, whatever affidavit they have filed, we haven't received a copy.
These are, sir, not to be submitted before the court. You ask her, ask him. Is your good colleague? Is not
Let it be on 7th, my lord.
These are, you have to understand each other, that's all. Or Mr. P.K. Roy Chaudhary, learning consultant. MS
MM Kotoki.
and
TR Sen, Lordship, for respondent.
no.
And you are taking response to 4 and 7, Lordship.
Chronologically.
Junior government.
I have submitted that they have filed their response. However, it's not placed on record. Registry to verify and placed with the record.
Let it come on 7th, madam.
And also Mr. So-and-so, then counsel. For respondent number 8, first wife.
First one.
Is also present. You are not filing anything.
I filed my affidavit in opposition.
You have filed.
Yes.
Then in that case, so-and-so all have submitted that they have filed this so-and-so. Let this matter be listed after 2 weeks.
Can it be on 7th, my lord? On 7th,
seventh. Yes.
Obliged.
Obliged.
My lord, matter pertains to refixation, my lord. At the initial stage of appointment, there is an issue regarding the fixation of pay. So, my lord, I am praying for a similar order, my lord. I am praying for a similar order.
Which one?
Which was at page 57 is the order, my lord. This code.
57.
Yes, my lord.
It's a covered case.
A covered case, my lord. This only prays that, my lord, the direction will be given to consider our case. If they find us eligible, then they will pay us. And the orders also reflect the same way, my lord. And in case
same department or what?
Same department.
Same department.
Page number
Why similarly situated? Why you need a direction from this court?
Similar matters are already disposed of, Lordship.
That's why I'm saying. Why you consider?
Lordship.
It's a covered case.
I have some.
So you are saying that. So you are saying that it's not covered.
It's not covered, Lordship. And earlier order was of the year 2009, Lordship. Now it is 2024.
No, in 2019 also, my lord, there was an order for.
Concerned employee was to give her
Okay,
option only because to be considered by the authority, and if entitled, then it should be given the refixation. But it was in going on 1991, it was only in respect of death pay revision.
This is your affidavit.
Affidavit I have not yet
Fine.
Affidavit I will file.
Then, it's a similar case of disposed of on.
Sir, he is objecting. It's not similar.
In 2023, the similar matter was disposed of. He is now 75. Page 75 is another order of this court. Coordinate branch of the court. WPC 2
Sir,
2019.
why you have a different submission? She said it's similarly. It's similar. Can dispose of
Only to verify after verification, Lordship.
They have to pay after verification. I'm not saying there's no maintenance.
Financial mail, yes.
They are, my lord, the A&Ms, my lord. All the ladies are there, they retired.
Anyway, we will consider, since he is objecting, otherwise we could have disposed of in the same line.
My lord.
Heard Mr. So-and-so, Learned Counsel for the petition. Mr. P. Nayak, Learned Counsel, Finance Department, has prayed for and is granted. Conference for and is granted for the 3 weeks time to file affidavit. 4 weeks. But you should sail in the same boat.
I am appearing for the provision.
All of you, all, you may also file affidavit. Don't have a conflict strength. It creates more problems. Then the solution.
Finance is the main.
We expect everyone. We expect every learned counsel for the solution. To assist for the solution, not for the problem, to create a problem. You are for?
Health department, Lordship.
Yes. Health department, finance, you should.
That instruction is from the health
You
department.
should speak in the same, not only same thing, you should speak. Not only same pitch and same volume, but it's in the same language. Yes.
May I date me fix? Can I date me fix?
After 4 weeks, yes. Yes, next. Next. There's a hearing at 2 o'clock.
Today,
Yes.
today I have filed an affidavit on behalf of
What
respondent
Mr.
number
So-and-so, London Council for the Petitioner, MS
A. Bora
Ebora, London
for respondent number 2 and 3.
State Council, London State
Standing
Council,
Council NHM.
London Standing Council,
NHM, National Health
NHM
Mission.
has submitted that she has filed the counter affidavit today,
Yes.
which is not on record. It's registered to verify and placed on record. This is the matter after 3 weeks. In the meantime, the petitioner may file their response, file their reply. Also advice. Yes, next.
My lord, 39, 40, 42, 43 all are arising out of same, my lord, issue. My lord,
Yes.
here my lord, the similarly situated persons,
39, 40.
42, 43.
It is similar.
My lord, that is not on similar footing because my lord may kindly peruse page 65, page 66, 43, 44, my lord. 39, 40, 43, 44.
39,
40, 43, 44.
42,
43, my lord, and 44.
43 and 44.
Same honor.
Four cases, four. My lord,
Same,
similar,
same.
same.
If you not.
No, my lord, there is. My lord, may kindly see page 65. The similarly situated cases came on last 4/3/2024. It was disposed of by this coordinate bench of this honorable court, my lord, 4/3/2024, and one was disposed of, my lord, again on 17/5/2024, granting similar relief, my lord.
Yes.
My lord, may kindly please be perused page 65.
Yes.
They have not raised any objection on those bunch of petitions, my lord.
Same
regard to
kind
issue.
of same
Same
order.
at 37.
My lord,
Lordship
it is
has
different.
given
They have
direction.
come against
No,
93.
no, no. No.
Submission to
Yes. First you.
my lord, those, as I was there, I had that those were of 90 or 2023 orders. But these cases were disposed of on, one was 4/3/2024, and the second was disposed of on 17/5/2024.
Yes.
In those cases, they were asked to obtain instructions. They obtained orally, and no affidavit was filed. And my lord, no objections was raised.
Yes.
On similarly situated ground, those petitions were disposed of. And what was disposal was that only to verify and consider, not consider, to verify. Only the honorable court passed the order at last was that since it was squarely covered, my lord, to verify whether their stand was correct or not. My lord, may kindly see the last paragraph at page 66. So I'm praying on the similar ground, my lord. Page 66, point number 5. Petitioner by
Review of the causes of the considered in terms of the
page 66, point number 5. My lord, they were not given any specific order. The court only said that to revisit the matter. And then again, my lord, the same at Annexure 7 also I have enclosed. Annexure 7 also, my lord, may kindly be pleased to peruse the page number 16.
So you want the similar order?
Yes, my lord, because court has only stated.
What is your grievance?
No, my grievance is that I have not been granted the benefit of ROP rules, my lord.
Okay.
So my lord, my prayer was that.
So simply you wanted the similar order.
My lord.
What do you say?
Lordship, I have received instruction because after giving some, after this order, similar order, some person has taken some benefit. But thereafter, the Accountant General raised some objection because finance concern is not there and others. Lordship may see the my
lord.
Because
AG was party, my lord, in those petitions.
And last order, AG was supposed to file affidavit. Yes,
my lord. Of less.
We'll continue it.
Instruction of Accountant General is still awaited.
3 weeks time may be granted to file our affidavit.
Which one?
In item number 39 and 40.
And this entire matter will be covered by the This I will
3 weeks, within 3 weeks.
No, it's a similar matter. Why unnecessary? Why affidavit is required?
Because we do not know, because on 39 it was instruction was given, so direction was given to file
The
affidavit.
same issue, same
19.
cohort, my lord.
19.
Same issue, 39, 40, 42, 44. Same issue.
Disposing on same line. Whatever you want to do.
This affidavit will
Have you filed an appeal against this order?
in item number 39,
No, this
39 and 40.
40.
page 60.
5. Page 65. My lord, bunch of repetitions came. Even my lord into my lord annex page 65.
Same department.
Same department, same petitioner, same everything, my lord. They have not objected in those bunch of petitions, my lord. And my lord, one case.
But in the pay commission's report itself, the time period has been fixed as 60 days. Thereafter, we are not going to come down. If they want to,
So whatever you want to do, what is the direction? What is the direction?
To revisit, my lord. My lord, page 66. No appeal has been filed against those orders, my lord.
It's a similar order, similar grievance, which already been disposed of.
My priority, Lordship will dispose of this. Mention observing that authority will look into the application representation to be filed by the petitioner on the basis of the report itself. They are also very specifically mentioned that it has to come within a period of 60 days.
See, what is this
And
order relied is what?
Not on earlier order.
Yes,
My lord,
which one?
My lord,
Page,
they were, my lord.
page.
My lord, it is not, my lord, they were not getting the benefit of the ROP rules.
No, what is
The
page?
order, page 65, my lord. Impure order, page 65. 65 is the order, my lord, of the, my lord.
Operative person.
No, my lord, my lord.
Start from page 65.
Appropriate, the page 66, paragraph number 5, the Honorable Court's observation.
In view of the above, the court is of the considerable in terms of the referred judgment and order that is passed in 2009 other connected matters. The issue regarding fixation pay is required to be revisited by the respondents provided while considering the case of the petitioner. This will be guided by the referred judgment and passed in civil rule numbers. So the entire exercise shall be carried out within a period of 2 months from the date of the subject.
And even my lord may kindly say page 57 also, similar set of writ petition. Page 57 also.
You are working as
A&M, my lord.
A&M.
My lord.
And these writ petitioners
Same A&M. Same A&M.
page 65.
Yes, my lord, page 65, and even my lord may kindly even be pleased to peruse page 57 also. Page 57, it was disposed of on 21 to 2022. Then my lord may be pleased even, my lord, even page 69, that was disposed on 17/5/2024. Say
So
page
we'll
16.
go for one order.
Yes,
Same.
Same, my lord, same.
Order dated to support, yeah.
And you are also.
I am also.
How many petitioners?
My lord, in item number 39, there are 3 petitioners. Then in item number 40, there are 6 suite petitioners. 43, there are, my lord, 1 petitioner. And in 44, my lord, 1 petitioner.
They are in the different post or same post?
A&M in different places.
A&M
In
and
different
these petitioners?
A&M, same, my lord.
432 this writ petition.
Yes, my lord, A&M, they are working as
A&M.
A&M. Yes, my lord.
We'll give the same direction. Whatever you want to do it.
An observation only, Lord. If it is filed as per the
No, we'll give the because this according to her, and prima facie also, they are same A&M,
Yes, that is the
working under the health department, right? And their claim, their grievance is the same. On the basis of the earlier judgment in 2009, this has been disposed of. Will dispose of the similar order in similar manner, but then whatever you want to do, if you cannot revisit whatever you want to do, who is stopping you from filing an appeal? Because if it is similar matter, I cannot have the different view.
Only Lordship will only record my objection.
And if I,
My Lordship will record my objection because it is a 309 rule. The Pay Commission's report is a 309 rule.
whatever you want to do,
Here it is specifically mentioned that such options should come within a period of 60 days.
why you have not said so in the earlier?
On that,
Have you filed any review?
Nobody in the from the finance.
Have you filed any review?
Otherwise, also it will not be accepted by the authority. That is all.
Whatever. Because what about these orders then?
It was not on the download.
What about these orders?
Today, at least your Lordship is aware about this rule.
Lordship, kindly see order dated 19/8/2024.
19.8.
19/8.
In this petition?
Yes, Lordship.
19.8. Time,
Yes.
they seek time to file affidavit. They haven't filed.
But AG will file affidavit. Lordship may grant at least 2 weeks time because let the
Let our instruction come.
Are you
Let-
taking some steps against this order,
I'm not
which they are relying?
My health department instruction is I am sending.
Earlier directions are concerned as well.
Kindly,
My lord, interesting. My lord, I would like to.
Just wait.
yes,
In that repetition, my lord, the reference may in that repetition they have filed even affidavit, and thereafter the honorable court has disposed of, my lord, with regard to page 65. This with regard to instructions in Rinamoni Kolita. In that case, my lord, they have filed affidavit, and after the filing of the affidavit, the honorable court has passed this page 65 order.
What is this?
My lord, I have sent you this. My lord, this reference is with regard to WPC 1984-85-2024 in Rinamoni Kolita. My lord, with regard to the instructions, my lord, may kindly see the next page. They have filed the affidavit at next page. After filing of the affidavit, the court has disposed of it on 17/5/2024, which I have NSS page 69, my lord, of my writ petition. Page 69 of my writ petition. On similar footing, after the filing of the affidavit, this was disposed on the same line.
after that case, this instruction has come. After Rinamoni Kolita case. Because AG has raised some objection.
Then what about the earlier orders of this court? What are you going to do it?
Let the AG's affidavit come, Lordship may dispose of the matter. No objection on that. Let the AG file the affidavit. What objection they have raised?
They have seek time earlier also.
At least 2 weeks time may be granted, Lordship.
They have seek time earlier also. On same line, my lord, no review or appeal has been filed against those orders. Those orders stands today, my lord.
2009.
2009,
1998.
2024, my lord, till today. The
Yeah,
others,
2009, they have relied, the coordinated bench has relied
Yes.
on the judgment of 2009.
Therefore, I'm praying for at least 2 weeks time.
98.
At least 2 weeks time, Lordship. Let the AG's affidavit
See,
come.
your doors are not closed. Whatever you want to do it, do it. But disclosing in the same line.
Okay.
All the restrictions.
Then, Lordship, my
39, what is this?
39, 40,
39, 40,
43, 44.
43, 44.
Lordship,
Same line.
Lordship, then
I
kindly.
don't have to tell you, sir.
Lordship,
98 order, 2009 order, what you have to do now?
This is a pay commission report of 1990.
Whatever.
Time limit was 60
You
days.
avail the remedy. Not before this court. We are
Lordship.
bound by this judicial discipline and propriety.
I am only praying not to.
If I don't agree only, if I am in disagreement, then only I can refer it.
I am only praying for recording my submission.
And it's not laying down the law. It is based on the 2009 as well as 1998 judgment of this court, which has attained finality.
And your lordship,
So I cannot have a different. I cannot review that.
This petition is liable to be
I
dismissed because of delay, lordship.
I cannot review. I cannot review that on my own. I cannot review those orders. So,
Lordship.
as a judicial discipline and propriety, I am disposing
Lordship.
in the same line.
My
Lordship,
submission, sir.
In the
Lordship,
same line, we are not laying down any law.
But your lordship will record.
It
my-
is basically covered by all this judgment,
Lordship, kindly.
allowed and disposed of.
Yes, Lordship. Lordship,
Obliged,
kindly record the my
Next,
Uh,
next.
my instruction may be record, Lordship.
In that case, 37 may also be considered the same line, my lord.
Why?
The same matter, my lord. Item 37.
It's over already. I passed the order.
All are same, my
You
lord.
No,
can
it's,
mention it.
37 is also, I think, same.
Same, my lord.
Same.
This is same, my lord.
You have not pointed out earlier.
Well, I pointed out, my lord, all the past judgments, but they said they have objected, therefore observed this, and they will file affidavit like that.
Similar also matter, Lordship.
Same A&M.
Same
Same.
ANM, my lord. They are among the same list, my lord, select list, my lord.
Item 37. Same.
37 also.
Do you agree?
No, I am not agree because someone else is appeared. So
But you-
inform the
but-
respondent.
But you said it's same.
It's same.
Because I have seen the
It's-
facts, Lordship.
It
because
is similar.
It's similar.
They are working as a A&M.
ANM.
You just inform it. Who has appeared in that
I have
case?
informed her, my lord. I will inform.
37 also. What about this 42?
Well,
Yes, sir.
I have done so, and I have also obtained the instructions over telephone. They were considered on merit, and from
They were considered on merit,
On
on
merit.
their own merit,
on
not on quota.
not on quota.
Obviously,
not on quota.
it,
And-
it clearly reflects also.
Lordship. And so, Lord, as indicated by your Lordship, Lord, they will redo the thing.
Revisit.
They will revisit it. And Lord, only my respective.
So will not
subordinate-
give a positive, as such to
Yes, yes.
appoint them or promote them from
Correct,
that day.
correct.
Will direct them to consider,
Lordship.
keeping
Yes.
in view the mandate of the law
Yes, true.
and the judgment of the Supreme Court, which
Yes.
which has been rendered in way back in 2016,
16, Lordship.
19, and all those.
Lordship.
Okay.
Lord, my one submission is there, Lord. Lord, the two petitioners are before Lordship, Lord, and they will hold the review DPC and consider the claim of these petitioners, because they said that in 11/1/2021 there was a DPC,
Yes.
and their 3 persons were considered on merit. The quota for the PWD was not considered at that point of time. From that point of time, the entitlement will on that quota will be considered, not in respect of the other persons, because if some persons are already retired, senior person retired, if it is reopened, then it creates difficulty.
We'll say in accordance with the law. By applying the mandate of the law of this Disabilities Act, then you can work out what is the what were the how many posts were there, what is to be, and almost you work it out.
Only
Just a correction, 11/1/21, that was not a DPC. DPC was obviously held prior to that, because 11/1/21, the notification.
Promotion.
Yes, notification was
Yeah,
published.
We don't know when the DPC
Yes,
was
that
conducted.
they will.
that is
We'll
the
refer to the order only.
order.
Yes,
11.
yes.
DPC will not say because it's not before us.
Yes.
When DPC was
Yes,
conducted, right?
that they will.
Fair enough.
Yeah, and the review DPC will consider the claim as raised by the petitioners only, because
we'll not say anything like review, or because it is your prerogative to have a review DPC.
Why I am submitting that?
Yes.
If one or two persons they retired in the meantime,
yes,
then if we see that the gradation list is at that point of time some senior persons were there, they were in service, the review DPC has to consider the senior persons. Ultimately they have to be considered, already they got pension and all these things they have got, but they are happy with that. Even the review DPC, then it creates difficulty.
No, ultimately what would be the purpose? For seniority only.
Only notional benefit to the extent of seniority.
Lordship will kindly.
Will not enter into all these things.
No, Lordship, just one submission. So, supposing the review DPC as directed by the court is held, and they consider a positive a decision is taken.
We're allowing your prayer.
Yes.
What direction would be? They will ask them to direct them to consider.
Yes.
Taking into account of the judgment of the Honorable Supreme Court as well as the mandate of the law.
Yes. Consideration for promotion.
They work out.
The seniority position, their seniority position is a relevant factor for that.
Yes.
So that is to be taken into
That's the reason why allowing, because if 1:4.
Yes.
They false.
Yes.
If we take that, if you apply the law, the policy or the procedure which you are following, that 1:4, they falls under the zone of consideration.
Sometimes, Lord, it may happen that they are within the zone of consideration, but considering the vacancy, they cannot be promoted because senior persons are there. They have indicated.
All these things, you work it out, it's her submission.
They have indicated.
There are certain areas, certain numbers of posts. And according to that, taking the ratio of 1:4, they fall under the zone of consideration.
Zone of consideration.
Apart from the quota, right?
Logic.
Admittedly, if it's not a quota, then obviously they will not be there, much below the senior. It is only because of the application of the mandate of the law we are allowing it and direct you to consider it.
Yes,
Lordship, what I want to submit is that if the DPC comes to a decision, yes, we were eligible in terms at that point of time, and decides to make a promotion with retrospective effect. Lordship, at that point of Lordship, the pay protection has to be granted with notional benefits.
We cannot assert the authority and power of the
No, Lordship, that will have to be indicated.
Notional benefit indicates that only.
That notional benefits will have to be given. Pay protection, Lordship. Lordship, I am not on that.
Pay protection obviously may be there because if rule permits.
No, Lordship.
But so far as the pay is concerned, the financial benefits, other than the pay protection and other things, you may have entitled to the pay protection, but not the financial benefit as such, because you have not worked.
No, I am not on salary, Lordship. We are on the Lordship notional benefit, because at that point of time, if our promotions are made with retrospective effect, so at that point of time, obviously, we had different pay scales will have to be given. Notionally, that has to be increased.
I thought I'll decide it's.
No, that is incidental.
In a simple line, but you are making it complicated.
No, Lordship, that is incidental to this prayer, because.
Let's see.
because that protection has to be given.
Let me apply my mind.
Lordship. Okay, this is the note as directed we have.
Yes.
Calculated.
That the statistics.
Yes.
That the regarding post and all the.
Yes.
You just share one.
Yes. I'll give
one copy to him also.
Malad.
So that Mr. Nut should not complain tomorrow.
No, I'll not.
That I have not been
No.
given the opportunity. It's just for the understanding of the facts.
I'll check.
So far as the statistics on the vacancy and all are concerned.
I have indicated, they have also agreed that we will ultimately it's a calculation. They have to recalculate. They will do that.
Heard Mr. MS. The Borgoy Land Council for the Petitions 6162. And also heard Mr. Dinar. Dinar, Senior Government Advocate for the State of Assam.
I'm preparing for response number 7. It's on the citizen only.
What do you want to say? Huh?
We have no role to play.
MS?
PP does.
PP does. London Council for APPSC.
APSC.
APSC. APPSC is Arunachal. Not Arunachal, it's a Pradesh. Hearing concluded. Judgment.
Malad. Only just
your first prayer were not considering anything.
Lordship, that is redundant because
it became redundant.
They have already modified that.
So only the second.
Only the second prayer.
There is a decision on this issue, Milord.
Yes.
In fact, this decision is I just like to refer. Lordship may kindly refer to that. I'll give a print.
Give the citation.
I'll give a print.
Yeah, what does it say?
Paragraph 12 and paragraph 14. It says that.
You mark it and give it.
Yes. I'll mark it and give it.
You just give the citation and paragraph number.
Yeah.
You print it out. Yes, you print it out. Judgment. Judgment, you print it out.
I'll take a printout and I'll give it.
Yes.
All of it.
Yes. Item 42.
This matter pertains to non-payment of gratuity.
Yes.
So I've been told that that they would take time, the other side, the respondents. They are supposed to file an affidavit clarifying as to whether I am entitled to receive the pension or not, my lord.
Yes.
The facts of the case is very simple, my lord. I have resigned from the department. I have joined NLLC after serving more than 7 years. So as per the Act, Gratuity Act, I am entitled to receive the pension. And so far as Central Civil Service is concerned.
This item 37, 39, 38, 39, 37, 34. It's disposal.
But here, my affidavit is awaited. Kindly give me 10 days time. I have already sent it.
Right. Date may be fixed, my lord.
Mr. D. Nath, Senior Government Advocate, press for in is granted 4 weeks time to file.
But already they have taken several times, my lord.
You are retired.
But they have taken several adjournments.
2024 matter.
But it's a payment of gratuity, but only the instruction will do, my lord. They are seeking time.
3 weeks. 3 weeks.
Date may be fixed, my lord.
After 3 weeks, give me date.
Gotcha. All of it.
Please, Your Lordship.
Yes.
For the office note dated 22/10/24, we are supposed to take steps to dusty service. That is not complete yet. So I pray that respondent 5 may be struck off. And regarding 1 to 4, service is complete. 1 to 4, service is complete.
Why? Respondent number 5.
5 is the driver of the vehicle.
Why is he discharged?
Because he is not that relevant party. Because the tribunal has already passed the award of pay in recovery. So if anything happens, we can recover it from the owner.
Mr. You
as the
as the counsel for the appellant submits them, the respondent number 5 may be stricken as the respondent 5 is not a necessary party.
I'm appearing for respondent number 1, 2, and 3.
Who is for 4? MS learned counsel. Appears learned counsel for respondent number 1, 2,
and 3.
3. Submits that she has no objection to such submission of the learned counsel. Considering that the name of respondent number 5 be struck off from the area type. Let's do matter after 4 weeks.
4 weeks. It can be fixed for hearing.
Already admitted.
Already admitted.
This the matter, since the matter has already been admitted. This the matter, this for hearing after 4 weeks.
Obliged.
May it please your lordship.
Yes.
Lordship, on the request of Mr. K.K. Bhatta, I am appearing in this matter. He is not present today.
Yes. What is to be done?
Lordship, I am praying for an adjournment.
You have to respond.
I am for the restaurant 1 to 5, lordship.
Okay. Who is for 6?
6, no one is appearing. In that
Service
respect.
complete.
Service complete.
Okay. MS learned counsel for the appellant. What is the IA?
I have for delay condonation, lordship.
Do you have any objection?
I have no objection, lordship.
Then
Lordship, I am not on record.
939 days.
Yes, I have no objection, lordship, then also. Because 2019 already listed first, then 2024, lordship.
We close this.
Yes.
Allow the condone the delay. And MS learned counsel for the petition, and counsel for the appellant, and also her
KK Dr.
learned counsel for
1 to 5.
Respondent number 1 to 5. 7. Who is 6?
6 owner of the vehicle, lordship.
None appears for the
And 7 was strike out.
Despite service of notice. Notice served.
Yes, lordship.
Despite service of notice. Next paragraph. By filing this application, the applicant has sought for has prayed for condonation of 939 days. And the condonation of delay of 939 days in filing the connected application. There is the grounds for condonation of delay. No, not before that. Learned counsel to the respondents has no objection to the objection. To the combination of delay. Next one, having considered the grounds.
Basically, ground number 4, lordship.
Having considered the grounds. As narrated in paragraph 4 of the application. and the prayer for conveyance should not be objected by the consequently respondents. I find that this there is a sufficient as I find that a sufficient false has been shown in preferring the connected epi in time, which has occasioned a delay of 939 days. Accordingly, I know the cause shown is sufficient, which has prevented the applicant to file the connected appeal. Accordingly, a delay of 939 days in filing the connected petition is hereby condemned. IA extends disposal, allow the disposal. In appeal, in view of the order passed in IA and so I state number the appeal and list for admission after 3 weeks.
2 weeks, that's it.
After 3 weeks.
Deeply obliged.
May please your lordship. So this
Yes.
is content petition lordship. Kindly there is order dated 18/12/23.
Yes.
Lanet Senior Government Council lordship sought for time to obtain instruction.
Where is the senior government advocate?
Please not there.
Just call him, inform him. Just inform. We'll take after some time.
Right.
May please your lordship.
Yes.
The matter pertaining to non-payment of retirement benefit.
Yes.
During the pendency of this contempt petition, my lordship, the petitioner died, your lordship. Then we have filed an IA for substituting the legal heir. That was allowed. We have filed a amended cost title, your lordship. Now the matter has come up before the lordship.
So what is to be done?
My lordship, new incumbent has also come in, so we will be granted some weeks to file a representation.
Mr. So-and-so, learned concept of the petitioner is permitted to take steps, press steps for service of notice upon respondent.
Sole respondent.
All respondents.
It's not for service of knowledge. A new incumbent in the post has come and they have to submit representation to him.
You
Yes,
have
this is a contempt
filed
matter.
an-
New incumbent has to
No,
be.
no. You have filed an, you have implemented him.
No, my lordship, we have to file a representation first.
Huh?
We have to file a representation first. To the
Then
new
we'll close
incumbent.
it.
My lordship,
We'll close the contempt.
my lordship, we have to implead him. We have to implead.
So you will have to file an application for impleading.
But before that, we have to file a representation, my lordship.
If you have to file a representation, how this will survive?
My lordship.
We'll close it.
No, my lordship.
Liberty, will granting a liberty to file a representation.
No, my lordship.
Then
Lordship may allow, my lord.
allow
To file a
representation.
No, my lordship, implement petition.
You said you would like to file a representation. What is the order? What is the page order of this court?
Is operative third lordship page.
My lordship, 8 to 9.
8.
operative portion is at page 9, my lordship. The last para, my lordship.
No, this is for the fresh representation before this within a period of 1 month from today, and the respondent within a period of 3 months from. Something is issued on the payment and leave encroachment with gratuity agent. So,
Lordship,
are you filing representation or are you implementing the new incumbent?
my lordship, as your lordship directs, I will do that.
No, not direct. Because have you filed representation earlier?
No, earlier one.
Have you filed a representation earlier?
Yes, my lordship.
Where is the representation?
Representation is at page 10, your lordship.
Yes.
10 of my content petition, my lordship. We have filed the representation.
Yes.
That incumbent has already been transferred. Only a new person is coming.
You cannot be absolved. You are for,
Yes, Lordship, but
you are for respondent.
I am for the respondent.
You will still be there in that case.
Yes, Lordship, I shall be there, but now the order has to be, the relief to be granted by other persons because I do not have that power now.
No, there is no contempt against the incumbent. We'll catch hold of you. Who are you? Who is the incumbent? Who is the respondent? Who is the respondent?
Only one respondent, Lordship. Sole respondent.
Sole respondent, my lordship. The managing director of Assam Plantation
Yes.
Development Corporation.
Where she is now?
She is transferred from this post. She
When?
is in Assam, Lordship.
When?
It was about 6-7 months back.
And this order was?
It was of 2022, I think.
2021, my lordship.
21.
At the relevant point of time, you were there.
Yes, Lordship.
Then?
Lordship, there is some development in the matter, Lordship. It is not that we are just sitting idle over the matter. Here, the government of Assam sanctioned some fund for payment of these to these persons, Lordship. There is some order, and I think the payments could be made during 1 month, within 1 month, Lordship. This is the order, sanction order.
Will. They'll be paid. You'll be paid.
Yes, Lordship. We shall pay them, Lordship. We are ready to pay.
This may be observed, my lordship. In the meantime, if it is not
We're recording it and closing
Yes,
it.
Lordship. Lordship.
Mr.
Yes, Raja, my lordship.
Learned counsel for the petitioner. Mr.
R. Sharma.
R. Sharma, learned counsel appearing on behalf of the alleged contender by placing the, what is this? Financial sanction issued by the who?
Issued by Lordship, the Soil Conservation Department.
Yes,
To the Accountant General,
no name,
A&E.
nothing. By placing the copy of the financial sanction, submits that the petitioner will be paid. What?
The dues in terms of order of the High Court, Lordship.
No, not in terms of. You said they'll be paid.
Leave encashment and gratuity.
Just wait.
This order is for 37 number of employees, Lordship. He is one of them.
Shall be paid the leave encashment and gratuity entitled to the petitioner within a period of 2 months. Within a period of 1 month.
Lordship, let it be 2 months. By that time, it may be done.
Within a period of 2 months, Mr. Having considered the submissions of the Learned Counsel for the alleged contender, the present contempt petition is still closed. The respondents, the authorities shall pay the leave encashment and gratuity to the petitioner within a period as undertakes within a period of 2 months from today.
My lordship,
Distance, close and disposal.
my lordship, some observation may be that I may be granted.
What
liberty.
more observation I can? It's okay. That's all.
If they do not pay my lordship, my
Already sanctioned, lordship.
but I haven't been paid yet, my lordship.
You come back. That's why they said within 2 months they'll pay.
Yes, my lord.
He said 2 months you'll pay. You want money or you want to keep litigating?
No, my lordship, ultimate aim is that.
Yes. Next. Yes, sir.
Lordship, as per occasional dated 22/10, Lordship,
Yes.
service on respondent number 2 and 3 could not be completed, Lordship. So one has already appeared,
This
Lordship.
is not found.
Yes.
Take press steps.
So, Lordship, before that we'll have to take instruction about their proper address. So first of
No,
all,
we'll take steps by after ascertaining the proper address.
Yes.
Mr.
Yes, sir.
Learned Counsel for the appellant is permitted to granted further 2 weeks time to ascertain the address and take press steps upon respondent number 2 and 3.
Yes.
You are one.
I'm going for
Miss
respondent
MS
number.
so Learned Counsel for the respondent 1 is present. List after 2 weeks we are granting to ascertain and take steps. List after 5 weeks.
Public.
My page, your lordship. Lordship, in this case, service is complete and LC has been received, lordship.
Yes.
So matter may fix for hearing, lordship. So, Diwali.
Appeal.
Lordship. Service is complete, lordship.
All are represented.
Yes, Your Lordship. I may bring for respondent number 1 to 4, Your Lordship.
1 to 4.
Yes, Your Lordship.
4 respondents.
6 respondents. Total 6 respondents.
I may
What
bring
about
for
5 and 6?
5 and 6 notice served.
Your Lordship at least.
Service completed. Already admitted.
Lordship.
Your Lordship,
Since
50% of
matter
the
has
amount.
already been admitted. List this matter for hearing after 6 weeks.
Your Lordship, 50% of the awarded may be released to the claimant, Your Lordship.
File an application.
Only there is a stay order, lordship. At the time of admitting the appeal, there was a direction to stay the all amount, lordship.
It's stayed.
Lordship. So
You
there
have
is a final-
deposited 50%.
No, lordship.
Yes. They can pay, Your Lordship, since the claimant is suffering a lot because he
file
was
it.
the sole breadwinner of the
Madam,
family.
you file an application.
Yes.
File an application.
Yes, sir.
Yes.
Apply, lordship.
Yes.
There's already standing. Let's see. There is stay also. Just wait. Earlier case. It's a till returnable date.
Lordship.
Till today.
Lordship.
You deposit 50%.
No, lordship. Lordship, we have challenged the award that the vehicle that was stated to be offending vehicle that was not, owner has stated that that vehicle was not included in this. The vehicle was not involved in this case, lordship. And we have exhibited the.
Where is this? What is the respondent? Anyway,
Apply, lordship.
but it stays till today.
Lordship. That may be continued, lordship. Stay may be continued, lordship. Interim order.
Don't know why. Anyway, interim order first, earlier shall continue. In IA, till the next step. In IA. Yes.
Next. Yes, please, Your Lordship.
Yes.
So last occasion we sought time to file an objection against the stay vacating, Lord.
Yes.
Lord, we realize, my Lord, if the matter is taken up for admission hearing, the entire matter can be disposed of.
This is for what?
This is otherwise listed for orders, my Lord.
For vacating the.
Interim order.
Why it should be vacated?
My lord, what happened, the petitioner is a union who got a registration under the Trade Unions Act. And I am the registrar of trade union. Having realized that the trade union registration was obtained by fraud and manipulation of documents, the trade union registration was cancelled by following the provisions of law as provided under the Trade Unions Act. Against that order, an appeal has been filed. Now that appellate authority, the labor court, the appellate court is hearing the appeal. Now, during the pendency of the appeal, they have filed an application saying that the labor court should frame issues and permit them to adduce evidence, which the labor court with a reasoned order declined.
That is against.
That is the order which is under challenge, under 227, my lord.
Anyway, in that case, we can dispose of the entire matter.
So since, and another thing, my lord, there is an order staying the labor court proceeding also, which is not even the subject matter of this present proceeding.
We'll see. Only for admission hearing. Only how many respondents?
Respondents
Only
are
one.
served.
Yes, is ready.
And yes, Chakraborty, counsel for the respondent. List matter for admission hearing up to 3 weeks.
My lord, some early date, my lord.
3 weeks. Admission hearing.
Yes, my lord.
Admission hearing.
My lord, since there is a stay vacating application, so
I'll keep it open.
the stay vacating, so can it be taken up after the, on any day on 11th of November?
After
My lord.
After 14.
After 14th.
So many matters have been picked.
18th?
18, 19, what?
In that case, 19th, my lord, 19th.
19, I think it's
a hearing day.
So it will
make
be
it 18. 18.
Interim to continue.
Interim.
Obliged.
Yeah, please, your lordship.
Yes, sir.
On the earlier date, this honorable court ordered to take steps upon the respondent. Likewise, your lordship, we have taken steps upon the respondent yesterday.
Yesterday only?
Yes, sir. Like, your lordship, due to the sudden demise of the learned counsel, DJ Haloy, there has been a delay, your lordship. My sincere
No,
apology.
office note said that you have not taken steps.
Yes, sir,
You
we
have
have
taken?
taken steps yesterday, yes.
Office note dated 23/10/2024 reflects that no steps have been taken by the petitioner for service upon respondents for service of notices upon respondent. However,
And your lordship, my prayer is that the interim
however,
order,
Mr.
El Hangzo, your lordship, El Hangzo, on behalf of non-counsel DJ
Submits
Haloy.
that he has taken the steps yesterday.
Yes, sir.
Yesterday, i.e. 24/10/2024. It's a good ground for vacating. They stay.
And your lordship, the
You
interim
have obtained
order,
the interim order and you have
yes,
not
earlier
taken the
passed,
steps
they kindly continue.
for a month.
Okay.
Interim order
They
was
kindly continue,
earlier
your
is
lordship.
vacated. Huh? You have obtained the interim order and you have taken the step after a month.
Yes, sir, there has been a sudden demise of the senior counsel, sudden demise of the father-in-law of senior counsel. That's why the matter has been inadvertently left out, your
Be
lordship.
careful.
My sincere apology.
Interim order first, I will continue. I've said vacated, no? You delete that. Interim order passed earlier shall continue. That's all.
Much obliged. I'm very grateful, Your Lordship.
Huh? After 4 weeks.
Standing item number 47.
Yes,
my name is not reflected. I missed the item. I'm sorry for that. Here, the person concerned, this is a mistake on his part.
You advise. You advise the officer.
There is in fact, I have communicated that there is a OM issued by the Chief Secretary of the State that no officer should directly write letter to the government, to the Honorable Court.
But
It's a
anyway,
mistake. It's a
you
mistake.
advise. And now what is to be done? Any instruction, you obtain instruction from the
letter which he has sent to the Honorable Court. I have just gone through the letter. His information is that the person concerned who has been named as respondent here, he retired already. So the incumbent who is holding the post now, he has to be.
Who has to comply the court's order?
Yeah, that's correct. He has to be. He has to be made a
find out and implement them.
Mr. Joyanto Guha is a respondent.
He'll be there. Ultimately, will have to be court's order has to be implemented. So you find out who is the new incumbent. Do you have any idea?
Well, the person who has written the letter, name and designation is available there.
You just share that.
Yes. They can collect it.
You find out and share it.
Lot.
MS Swenson and counsel for the petition. Learn counsel for the petition. Mr. Dinner, in terms of the order dated 18/12/2023, Mr. Dinner and the senior government advocate has submitted that he will ensure that such mistake is not committed in future. He further informed that there is a notification in this regard. There is a notification issued by the government.
OM is there. I have a copy in my
notification which has been issued by the government. That what does it say?
No officer should directly communicate to the Honorable Court.
To the extent that no officers shall directly make an directly contact with the Honorable Court.
But this is dated office memorandum dated 3/1/2024.
Office memorandum dated 3/1
2024.
2024.
I'll hand over a copy to the court master.
MS Swenson and counsel for the petition is granted for the 3 weeks time to file appropriate application for implement of the new incumbent list after 4 weeks.
In the other case, this is the judgment. I'm giving a copy. I have just noted the paragraph. Here, the notional benefit has been given. That is the
62. 61, 62. Yes.
Lordship,
Yes.
I am appearing for respondent number 1.
Yes.
Lordship, today I filed Wakalat number.
So,
the service is complete and OPL already admitted and LCR also received.
It's already been admitted.
Admitted, Your Lordship. By order dated 18/7/18.
Listed for hearing.
Your Lordship. First week of December, Your Lordship. Any date.
Learn counsel for the appellant. Mr.
A.R. Mondal.
Learned counsel enters appearance on behalf of
Respondent number 1.
respondent number 1.
Lordship, I am appearing on behalf of respondent number 2.
Ms. M.S. Swenson appears for respondent number 2.
Wait for a date in first week of
list the method after list for here. List the
first
method
week
for
of
hearing.
December. Your Any date?
In the last
first week of December.
first week of December.
Bless.
Also, kindly see the office note dated 22/10/24.
Yes.
Respondent number 2 has not been appeared. Lord. Also, kindly allow me to take place stay upon respondent number 2.
Mr. So-and-so, learned counsel for the petition is granted 5 days time to take these steps upon respondent number 2. Just after 4 weeks. You take it for 5 days.
May I please? Lordship, appeal has been admitted, service has been completed, but LCR has been not received yet. So remainder.
LCR has not been received.
Yes, I can.
SP Sharma, Lordship, for the sole respondent.
Sole respondent. Call for the trial court record.
Kamrup Metro, MEC number 3.
From the learned tribunal. Kamrup Metro.
Kamrup Metro, member number
from the MSCT, Kamrup within bracket M bracket close. Only that much. In MSCT, MSC case number. MSC case number
2536 of 2016.
2536 of 2016.
So
list for hearing after 4 weeks.
After receiving the LCR.
So after on receipt of the trial court record.
So
Hello, the final IA, my lord.
Yes.
Sir, by the imperial order, salary has been treated to be a public document, my lord. Peculiar, my lord. Supreme Court, three judges bench said, my lord, that it is a private document. Certified copy is to be proved as a secondary evidence. Now, my lord, against that, my lord, we have filed a
IA,
my lord. Because the last date is fixed on 28/10, my lord. I have to put it. So I pray that title suit, further proceeding of title suit may be stayed till appearance of party. Hearing of the.
You will issue notice and in the meantime we will stay. All right. We'll pass the dispose of the IA finally after hearing. Third, Mr. G.N. Sahewala, the senior counsel assisted by MSK Bhattacharya, the counsel for the applicant next paragraph. By filing this, no, this is an application praying for interim order.
Staying further proceeding of title suit number 74 of 14.
For stay of the further proceedings of title suit number 72 of 2000.
72 of 2014.
72.
Yes.
2014. Pending before the which court?
Well, in the court of the civil judge Tezpur.
Senior division.
Senior division Tezpur. Junior division Tezpur.
Civil judge junior division. Within bracket junior division. Civil judge
junior division Tezpur.
Within bracket junior division, comma Tezpur.
Number.
Issue notice to the respondents. Applicant to take stress for service of notice. Respondent number. All the respondents, even performer.
Performer stack up, I shall stack up, not necessary. Profile notice.
Respondent number 1.
1.
Consider me submissions. The legislative council and the perusal of the order impugned. The in the interim. No, not the interim. Till the returnable date. The further proceedings of title suit number 72 of 2014 shall remain stay. Till returnable date.
Well,
yes.
May I please, Your Lordship?
Yes, sir.
Your Lordship, yesterday the case was fixed for one. It's an IA for release of the deposited amount.
Yes.
I have filed objection, my lord. In this case, my lord, they have filed the application under 166 of the NBI. 2 vehicles were involved. One vehicle was driven by the deceased. Another vehicle was insured with the appellant company. My lord, they have exhibited the exhibit number 1, that is accident information
Okay,
report.
it's a better of deliberation at the time of hearing of the.
No, my lord,
It's okay.
the
Already
claimant
deposited.
Already deposited.
the
Your
claimant
Lordship,
withdrew the
I have-
amount. They were given some security at the time of
indemnity bond, yes, that much I can do.
Indemnity bond.
That can be done.
Yes. Or Mr. D. Mandal, learned counsel for the petition, and the applicant, and also had MS
S. Roy
S. Roy,
for the sole respondent in the application.
learned counsel for the opposite party appellant, huh?
Yes.
Opposite party appellant. Next one. By filing this application, the applicants, only one.
Only one.
Applicant has prayed for a direction to allowing the applicant to withdraw 50% of the awarded amount, which has been deposited before this court, before the registry of this court, in terms of the order dated 01/12/2023, passed in IA 34 IAC, bracket close 3472 of 2022, in the connected MSc appeal 425 of 2023. Why you should be allowed to withdraw?
Your Lordship,
Mr. Mandal?
Your Lordship, in the paragraph number 4, the applicant says that the accident occurred way back in the year 2017 until date.
Mr. D. Mandal, learned counsel for the petitioner, applicant submits that the accident had occurred way back in 2017. Until that, the applicant has not received any amount of the awarded amount. It submits that in view of non-receipt of any amount of the awarded amount, the applicant is facing untold miseries and hardship which had occurred due to such accident. Therefore, it submits that a direction may be given to the registry. Therefore, he submits that the applicant may be allowed to withdraw 50% of the awarded amount deposited by the appellant in terms of this order of this court. What is your submission?
I have in paragraph 6 of my objection petition.
Saying what?
that the claim that the deceased was riding the scooty in a drunken condition, my lord, and she hits the Baker and Gold insured with
MS.
the company.
So and so. On the other hand, while objection to the prayer for withdrawal of 50% amount deposited, 50% of the amount awarded, 50% of the awarded amount deposited before the SC of disclosure submits that the applicant was
No. Deceased.
The deceased was riding
Her scooter in a drunken condition.
her
Scooter.
in a drunken condition, which cannot be faulted with the accident involved, as it was due to rash and negligence.
Then driving of her scooter, not
Rash and negligent driving of the scooter on the part of the deceased.
the vehicle involved.
There is a likelihood of allowing this appeal, which likelihood of there is a every sense. No, there is a likelihood of there is every sense of allowing this connected appeal. Therefore, the applicant is not entitled to withdraw the 50% of the awarded amount as deposited. Next one, having considered the solicitors and learning counsel for the court and on the perusal of the materials, I deem it appropriate to allow this applicant, allowing the applicant to withdraw the 50% of the awarded amount as deposited before the registry of this court. Accordingly, the applicant is allowed to withdraw the 50% of the awarded amount as deposited from the registry of this court by furnishing
An indemnity bond of like amount. Of like amount, same amount.
Indemnity bond of the like amount. The registry is directed to release the 50% amount to the applicant.
50% of the award.
50% of the awarded amount deposited by the appellant by after proper identification. The IA stands allowed
By accepting. Your Lordship, by accepting the indemnity bond, this may be reflected.
like amount.
And the main appeal, my lord, LCED has been called for, but it has not received. Reminder may be given, my lord. In the main appeal, LCED was called on 27/3/2024.
It has not been received.
It has not been
LCR,
received.
There is to send reminder for.
It is from Kamrup only.
Trial court record. Supreme Court has deprecated.
Yes.
Calling this court as lower court.
Yes. Trial court record.
We'll have to say lower court or the district judiciary.
Yes. Highly obliged.
List the matter after. What is it? Reminder, send reminder for trial court record. List the matter after 4 weeks. And list the matter for hearing.
Yes.
After receipt of LCR.
After receipt. List the matter after receipt of the LCR.
Much obliged.
Highly obliged.
Yes, madam.
Lordship, I have filed this application seeking extension of 3 months' time to implement the order, Lordship.
Yes.
No objection. Though I don't have the brief today, my name was not shown, but then no objection, my lord. I have
No
gone
objection.
because since they are
Yes.
implementing, my lord, we are always happy with that.
Maybe it's matter of time only.
Well, matter.
Ultimately, it has to be implemented. 3 months.
3 months. I have filed it on 16/9, so Lordship may count it from 16/9. So 16/12 or by 31/12 maximum.
31.
31/12.
Work out what will be the next step.
Lordship?
Just work out, calculate it from 16/9.
16/9 it is 16/12.
16/12.
16/12.
So we'll make it 16/12. Her MS.
B. Sharma.
B. Sharma, learned counsel for the applicant. Learned CGC.
Lordship.
For the applicant and also Mr. B. Hatak, learned counsel for the opposite party.
Opposite party writ petitioner.
Opposite party writ petitioner. Next paragraph. This is an application praying for seeking further time of 3 months for implementation of order of this court, that is 26/7/2024. Next paragraph. This court. Where is that order?
Lordship starts from page 12.
Page 12.
Yes, Lordship. 15 is paragraph 14 of page 15 is the
Next paragraph. This court, by the order dated 26/7/2024, in WPC 2516 of 2023, has directed the respondent authorities, applicants, to communicate the entry of the remorse in the ACA to the petitioner, to the opposite party of the petitioner within a period of 15 days from the date of the order, so as to enable the petitioner, opposite party of the petitioner to file a representation against such entry remarks in the ACA. So you will communicate. Only to communicate.
no, Lordship. My instruction is that they are implementing. So
Okay.
they need so for all procedural they need some more time.
If it further held that it has further observed that if the ACR is not communicated to the opposite party of the petitioner, no. Mr. If the ACR is not communicated to the opposite party, it has further directed that the respondent shall ignore the uncommunicated entry of the groomer in the ACR of the opposite party petitioner. And if the petitioner is otherwise eligible to be considered for promotion in the post of superior measure of the DD, and in his case shall be considered within a period of 15 days thereafter in accordance with the law. Next page. MS Bora
Sharma.
B. Sharma submits that the applicants of the responding authorities are ready to are in the process of compliance of the order of this court. But sometime would be required. At least 3 months time would be required to fully comply with the order. Mr. Therefore, she prays that further 3 weeks,
3 months.
3 months time from the date of filing of this application. Next prayer. Having considered the submissions and the prayer not being objected to by learned counsel to the opposite party petition, I deem it appropriate to allow this application accordingly. Further, 3 months time from the date of filing of this application is granted to the applicant respondents, responding authorities for compliance of, for implementation of the order of this court dated 26/7/2024, passed in WPC 2516 of 2023. It is made clear that by on or before 16/12/2024, the respondent shall, the applicants and respondent authorities shall implement the order. Order of this order. Order dated so and so. Order dated the court's order. 27. The application IA states allowed